major contribution to it?
There's really no major contribution, Your Honor. I do what I am supposed to do. I did what I am supposed to do. I am asked to dispose of my cases, that is what I do. There is a timeline, I follow it. I work professionally well with my colleagues, and I respect their decisions. I guess that's it, Your Honor.
And what traits do you have now that you want to bring to the Supreme Court, if appointed?
Yes, Your Honor. I have a breadth of outlook where I listen to the advice of my seniors. I am still not old. I'm 62. I guess I could still work perfectly well. I could do long hours. I guess if fortunate enough, I will be able to bring it to the top tier of the court.
Justice Garcia, you were appointed to your current position in 2005?
Yes, Your Honor.
Okay. Now, in your 13 years the Court of Appeals, with the Court of Appeals, what do you think is your most significant contribution to it that is not common to the other justices?
Your Honor, I was appointed in August of 2005, so that makes me, that brings a total of 14 years of service in the Court of Appeals. My principal contribution as a justice of the Court of Appeals is having been awarded a plaque of recognition for zero backlog cases in 2009 on the occasion of the centennial anniversary of the Court of Appeals. I started initial caseload of 350 cases in 2007. That means when I got the award, it was already zero. And I have been continuously working on that zero backlog up to now. In fact, the cases that I have decided are mostly raffled or declared submitted for decision in the same month or at the latest in the previous month. We have to be diligent in monitoring the flow and aging of our cases, so much so that we even have to follow up with the assigned division clerk of court to prioritize the submission of agenda of cases that are already ripe for decision. In addition, the completion, while I have an average of 150 completion or cases under completion stage, definitely it cannot be decided yet because we have to await for the period to lapse for the parties to comply with the submission of the required pleadings. Another significant contribution, Your Honor, despite the diligence in decision making, one of the committees assigned to me was the Building and Grounds Committee. Since then PJ Andres Reyes had a long stint of 8 years in the Court of Appeals as presiding justice, we managed to construct and renovate practically all the buildings and rooms of important divisions and departments in the Court of Appeals to the extent that they are now at par with the buildings and facilities in the private sector, Your Honor. Thank you.
Now, you said that you have decided a total of 922 cases for the past 5 years.
Yes, Your Honor.
And only 3 have been set aside and reversed by the Supreme Court. Is that correct?
Yes, Your Honor.
What are these cases, and were you convinced with the reversal?
That number was provided by our Judicial and Records Division. It was not unilateral on our part. In fact, all the applicants asked for the same statistics from the Judicial and Records Division of our office. Unfortunately, for lack of manpower, that has been repeatedly asked of the applicants. What are the specific cases that have been reversed or set aside by the Supreme Court? The Judicial and Records Division...
Just don't go into specific, just in general.
Your Honor, we are not provided with the specific cases that were set aside by the Supreme Court. That has been our proposal and request not only to the head of the JRD and our PJ as well, but up to now it has not been implemented. At least even to the ponente or the members of the division that decided that particular case.
Anyway, with those reversals, were you convinced?
Since we were not provided with the particular case, there's no basis for me to either agree or disagree, Your Honor.
Okay. How many times have you been shortlisted?
7 times, Your Honor. From
7
the time
times. And what
I
made you
started.
apply again?
Just like the others, we have attempted in a number of times. We are hoping that next time we will be fortunate enough to be to get the blessing of the appointing power, Your Honor.
Justice Singh,
Yes, Your Honor.
you just started at the Court of Appeals Manila in 2014. Is that
In
correct?
Cagayan de Oro, Your Honor, in 2014, March, but in Manila, 2017, Your Honor. I think also around March.
Now, don't you think it's too early to leave the Court of Appeals?
I'd like to think, Your Honor, in all humility, that when the framers of our Constitution decided to set the qualifications for the highest court of the land at the age of 40 and also the 15-year experience, that they were imbued with wisdom and had thought about it deliberately and decided that any person who satisfies those qualifications is competent and able to serve in the highest court.
The next question is somewhat personal.
Okay.
I know you to be single,
Yes, Your Honor.
but in your PDS you listed the names of your children.
Yes, Your Honor.
Do you have children?
Yes, Your Honor. I have 4 children.
Okay.
My marriage was annulled in 2004.
I see.
Yes, Your Honor.
So the first time we met, that your marriage was already annulled.
The first time that we met.
Yeah.
Yes, Your Honor. Yes, Your Honor.
When you were still a
trial judge, Your Honor.
A trial judge.
Yes. I believe that we met because...
You were in Bacolod,
yes,
you went to the house.
for small claims. Yes, Your
Yeah,
Honor,
okay.
because E.J. Lorna was one of our pilot
Yeah,
courts.
yeah.
Yes, Your Honor.
Anyway, it was reported last year that you had a strong dissenting opinion about the decision on the dismissal of the murder case against former Palawan Governor Joel Reyes in connection with the killing of broadcaster Jerry Ortega in 2011. Tell us about this dissent.
Okay. Your Honor, there is still a pending motion for reconsideration with us of our decision, including my dissenting opinion. So if I may be excused from
Okay.
commenting.
Yeah. Many of your contenders also come from the Court of Appeals. What do you think is your advantage over them?
Okay. I have great respect for my colleagues, especially the 2 who are with me here today. Justice CRUZ was with me in Quezon City, and Justice GARCIA has been my chairperson. And I respect the 2 of them. But I have to answer your question. So setting aside humility, I want to think that the thing that I have that or that I have more than the others is my reform work. I've been in reform since my Metro TC days, and I guess that is a sign of how I'm able to think of new things that can help the court address the problems that beset it, principally about docket congestion and case delay, and also about issues on, transparency and accountability. I think my record will speak for itself in regard to that. And even in the Court of Appeals, I have not just concentrated on adjudicating the cases assigned to me. I've also been very active in several committees. For 83 years now, the Court of Appeals has never had a lot in its name. And so when I was transferred to Manila, I initiated, together of course with the presiding justice, discussions, and we were able to option a land in BGC for the Court of Appeals to transfer to. And Your Honor, we were successful in securing a budget, the entire amount for the purchase of that lot. So that is one thing that I think is important for the institution to have its own home that we can call and our own, and that we can leave for the future generations. But also in terms of reforming or reforms in the Court of Appeals, Your Honor, I sit on the Rules Committee and also the Raffle Committee. So important issues regarding the processing of cases go to that committee, and I've been very active in contributing to the resolution of these cases, Your Honor.
Okay, thank you. Deputy Commissioner Cui David, good afternoon. How long have you been with the BIR?
Your Honor, I joined the Bureau in July 2016.
Only recently?
Yes, 3 years, Your Honor.
Okay. Now, you are only 51 years old,
Yes, Your Honor.
and before becoming a BIR commissioner, you were a practicing lawyer earning enough or even more. That's what your SALN showed us. Why did you decide to shift to the government?
Actually, it was a challenge for me to join the Bureau of Internal Revenue. First and foremost, I have been in practice for more than 20 years, and during the time that I joined the Bureau, I was already enjoying my practice. It was at the height of my practice. But then the challenge of serving the government made me decide to join the Bureau and accept the appointment.
Your law office was David, Cui David, Buenaventura, and Ang offices?
Yes, Your Honor.
Okay. Now, from being a BIR commissioner, you are now vying for the post of an associate justice. Is this really the career path that you are trying to build for yourself?
Your Honor, actually, when I was in litigation, I developed this interest in joining the judiciary. But at the time, I could not leave our clients. No, I cannot leave them behind. And so I had to set aside my dream and continue with my litigation practice. Now that I'm more than 50 years old, Your Honor, I realize that it's about time that I should follow the desire of my heart, and that is the judiciary.
Your firm, the David, Cui David, Buenaventura, and Ang offices, was the law firm tapped by Janet Napoles to defend her in pork barrel cases at the Anti-Graft Court Sandigan in 2014?
That's correct, Your Honor.
And not long after that, you were publicly known to be the one who handled the 17.46 million tax evasion case that was filed against the younger Napoles before the CTA, Court of Tax Appeals, correct?
Yes, Your Honor, that was before I joined the Bureau.
Yes. So following that timeline, can it be said that you are working out with your appointment in the BIR while working for the tax evasion case?
My appointment with the Bureau was a sudden decision, Your Honor. We did not plan for that.
So if that were the case, don't you think people in the BIR see your credibility tainted because they knew of your previous engagement before you?
I don't think so, Your Honor, because I could honestly say, Your Honor, that in my 3 years with the Bureau of Internal Revenue, I never asked about that case, the case of younger Napoles. Even if I had a chance to talk to the handling lawyers, never did I ask them about the status of the case. That's it, Your Honor.
Now, aside from the Napoles case, were there any other big controversial tax cases you handled before?
That was the only one, Your Honor.
Only one. Were those experiences helpful now that you are with the BIR?
My experience as a litigation lawyer, Your Honor.
And also with the handling of a controversial case?
There was no relation to my present job, Your Honor. Right now, I am the Deputy Commissioner of the Information Systems Group.
Okay.
And we are in charge of the development, enhancement, maintenance, and operation of the entire BIR systems, Your Honor. So nothing to do with cases.
Now, if appointed as a justice of the Supreme Court, you still at today, no? You are 51.
Yes.
You will still have 19 years before reaching the mandatory age of retirement. It will be a long journey indeed. So cite some new and long-term programs that you have in mind that you want to initiate for the Supreme Court and the Philippine judiciary in general.
I believe, Your Honor, that my experience with the Bureau of Internal Revenue will help me. If given the chance to be, if I will be given a chance to become a member of the judiciary, I will be able to introduce innovations and reforms in terms of technology, Your Honor. Right now, we are doing the digital transformation program in the Bureau of Internal Revenue, and all government agencies or all organizations are now going digital. I believe that that can help me a lot if I will be given a chance to serve the judiciary, Your Honor. Help in the modernization of the judiciary, electronic
By the way, you were scheduled
record.
to appear before this panel last Monday, and but you didn't.
I apologize for that,
yeah,
Your Honor, but I requested early on that I'll be scheduled Wednesday or later because I had to attend the study visit with Inland Revenue of Singapore, Your Honor. That is the counterpart of BIR in Singapore, and I don't want to miss that opportunity, Your Honor. That's why I requested for transfer of my schedule, change of schedule.
Thank you.
Thank you, Your Honor.
Justice Cruz, the Ombudsman yesterday wrote letters to Senator Laila de Lima and former Interior Secretary Marojas, asking them to explain why the IRR of the GCTA law did not exclude heinous crimes. Rojas, on the other hand, said that contents of the IRR were based on the law and that they are the target, and that they are now on the target of the controversy to divert the attention of the public from the Bucor officials who allowed the release of the inmates. Your take on this, please?
The Ombudsman, Your Honor, under the Republic Act creating the said office, has ample power. Even, in fact, even without a complaint, it could motu proprio act on a matter which he thinks is vital to the interest of the government. By asking the former Secretaries of Justice and Department of Justice and local government, I guess it is within his authority to do so.
So, Rojas was not correct in saying that the purpose of this was merely to divert the attention of the
Well,
public.
politics is beyond me, Your Honor. Because when he said that the purpose of the investigation is to divert attention, we will now be dwelling on politics. I guess that is beyond me.
Okay. Thank you. The Department of Foreign Affairs said that the Philippines will soon accede to the Hague Service Convention, a treaty that simplifies the process of serving court documents on parties living in another state. It has been said that it will address court delays and simplify the serving of summons and other court documents in a foreign jurisdiction. What is your take on this, Justice Singh?
Well, Your Honor, that is a welcome development indeed, because having come from the trial courts, we are all aware how much delay is occasioned by our inability to serve processes on both individuals and entities who do not maintain a presence in the country or who do not have representatives. So if a system is adopted in accordance with that convention, which will help address this particular problem, then it will certainly speed up the disposition of cases involving these foreign or non-resident individuals and entities.
Okay, thank you. Senators Gordon and Zubiri last week filed separate bills meant to create a separate facility for heinous crimes convict to isolate them and prevent them from committing more crimes. Your thoughts, Justice Garcia?
I totally agree with the proposed bill, Your Honors, for the segregation of convicts who have committed grave felonies and sentenced to the maximum penalty of reclusion perpetua and life. This will prevent them from, firstly, for security reasons, prevent them also from escaping and enjoy special treatments as have been criticized recently. The law permits that. The only requirement is that the separate facility be under the control and supervision of the Bureau of Corrections. It has many advantages. In fact, this has been done in many countries, developed countries, where they can afford the maintenance of a separate facility away from the population, in effect also drawing a line of harm and danger to the populace as well, Your Honor.
Deputy Commissioner Cui David. The Supreme Court dismissed the writ of kalikasan suit filed by lawyers representing fisher folk from Palawan and Zambales, seeking government action on the disputed areas of the West Philippine Sea. The Supreme Court pointed out that unusual proceedings when the Office of the Solicitor General, as counsel for the respondents, presented sworn statements from some of the petitioners saying they had no idea of the petition. Now, if you were to look not at substantive issues, if you were to look at substantive issues, will you grant the petition?
On the substantive issue, Your Honor.
Substantive lang.
I will look at the issue, Your Honor. Writ of kalikasan, it is a remedy available against unlawful acts or omissions committed by certain individuals, private entity, private individual, entity, public official, or employee, when there is an imminent danger in the environment, Your Honor, in our natural resource, in our resources, Your Honors. I think we need to preserve our environment, Your Honor. That's why I believe that that petition should be given attention, Your Honor.
Okay, thank you. If appointed to the judiciary or to the Supreme Court, what reforms would you want to initiate in the Philippine bar exams? And is pass or fail system of checking paper practicable? Justice Cruz?
There is a proposal that the bar examinations be patterned after the California bar exams. That it's just a matter of putting an X to the questions asked, then go for the bottom line. And that makes or unmakes you as a lawyer. But I guess the present system now works. That the questions asked of the applicant proves of the applicant his ability to tell the examinee of what the law is. I guess the reform there would be limited to the kind of graduates that are produced by law schools. Not entirely, not on the set of questions asked.
The United States urged the Philippines to craft a code of conduct in the South China Sea among countries in the ASEAN. If this crafting of a code of conduct will push through, will it be consistent to international laws and treaties which the Philippines is a signatory, or will it violate some? Justice Garcia. Repeat. The United States urged the Philippines to craft a code of conduct in the South China Sea among the ASEAN countries. If this will push through, will it be consistent to international laws and treaties which the Philippines is a signatory, or will it violate some?
It will be consistent, Your Honor, with the international law.
Why?
Treaties are generally binding among the signatories, but apart from that, customary international laws that are recognized or recognized international laws, the other non-state parties, though not signatories to the treaty or executive agreement, have to follow. And this will be beneficial to the ASEAN countries, considering it is China, the powerful nation which tries to claim the entire China Sea on the pretext of the 9-dash line, which was already invalidated by the Permanent Court of Arbitral Tribunal, except that it cannot be enforced by the Philippines and other neighboring countries. Negotiated, acceptable sea of conduct defining the rights and duties of each from their baseline up to the high seas and the reefs, Scarborough, and the rest that are being claimed by China will be delimited in terms of navigational sea. In fact, recently even navigation on the high seas, where the element of free passage is has been put to issue by several countries, China, US included. So it will be definitely beneficial to the participating countries as well as non-member states, Your Honor.
Okay. Differentiate judicial legislation from judicial restraint. Justice Singh.
Your Honor, judicial legislation is when the judicial power is exercised, well, supposedly to fill gaps in the law that is at issue before the courts. And so it entails going beyond the manifest intent of the legislature, as opposed to judicial restraint, where the judicial authority restrains itself from interfering with the spheres constitutionally apportioned to the two other branches of government, the executive and the legislature, Your Honor.
Okay, thank you. In his recent visit to Beijing, reports said that the president raised the Philippines' arbitral win to his Chinese counterpart Xi Jinping. But according also to the report, the meeting concluded with Xi not recognizing the arbitral ruling. Both leaders, however, agreed that overlapping claims in the strategic waterway did not derail or diminish the amity between the two countries. But on the other hand, former Foreign Affairs Secretary Albert del Rosario said in a statement that accepting China's rejection of the Philippine arbitral win would be a betrayal of the trust we have placed in our governance. Is it tantamount to betrayal of public trust? Deputy Commissioner?
I don't think so, Your Honor. Actually, it is said, Your Honor, that even the arbitral court has no power to enforce its arbitral ruling, Your Honor. Under the circumstances, that is the best thing that the present government can do. Follow up with China. For us to show that we are not sleeping on our rights, we are not abandoning our sovereign rights over the dispute in the West Philippine Sea, Your Honor. That act of the president means that we never waived on our right, Your Honor. And in addition, Your Honor, we have been filing a number of diplomatic protests, Your Honor. This, again, Your Honor, show that we never gave up on our sovereign rights.
Thank you.
Thank you, Your Honor.
Sogie Bill is now S-O-G-I-E. Bill is now one of the favorite topics in social media and other platforms. For you, how important is religious belief in discussing LGBT plus issues in general? Justice CRUZ.
Allow me, Your Honor, to start this way. Decades ago, women would argue that they are discriminated by men. That because the argument then was that women just belong to the household. They prepare the house, wait for the husband and the children, and clean the house. But then the winds had changed. They are now all over. They have been empowered. So much so that we have now plenty of lawyers, lady judges, and lady professionals. And in fact, they are now allowed to bartend. So more or less, under the Equal Protection Clause, it has put women in the level equal to men. But then, a new dimension has cropped up. There are male who would wish to be female, and there are female who would wish to be male. And asking the public that the public be kind to them. that they be understood and not discriminated upon. Of course, that is fine. But then, however, it also offends the sensibilities of others. I guess that is an issue that the Equal Protection Clause has to resolve. The SOGI bill outlines some don'ts. It lists acts that are prohibited. Some of those, I think, would touch on religious freedom. So much so that it would require public understanding, legislative action, and judicial decree. It could not really be solved overnight. There should be a lot of data, a lot of study before this is solved. And in fact, if you are going to ask me if my view on its constitutionality, it would be injudicious of me to say that it is either unconstitutional or constitutional on the basis of the depth in my knowledge of the matter.
How about you, Justice Singh? Is religious belief that important in discussing the LGBT plus issues?
I'll have to say yes, Your Honor, and agree with Justice Cruz, because the issue is discrimination. And discrimination is wrong if it is without a purpose or if it is for no valid reason. But if, for example, my religious belief is what impels me to act in a certain way, which is thought or seen to be discriminatory against, for example, an LGBT, then my religious belief should be taken into account. And so religion will have to figure in the debates on this particular proposal, Your Honor.
Thank you. By the way, what is the doctrine of processual presumption, Justice Garcia?
In case you offer a proof of foreign law, for instance, you have to present evidence to prove or establish that it exists. Otherwise, local or national laws shall prevail, Your Honor.
That's the convention of Phil. Yes, yes. A Deputy Commissioner, what's the difference between, or rather differentiate between the divorce and the declaration of the nullity marriage?
The declaration of nullity of marriage under the Family Code, Your Honor, and the divorce, Your Honor, are we referring to the divorce bill?
Differentiate between the two.
I believe, Your Honor, that...
Why is it that we have now the declaration of marriage as a nullity, while there are people who oppose the divorce bill, if ever filed? Or was it filed already?
I heard about the divorce bill, Your Honor, and based on what I learned, Your Honor, the divorce bill provides grounds for divorce, which are not available of course, in the Family Code, and these are more lenient grounds, Your Honor. So you can one can easily get divorced than the declaration of nullity.
Which has the more lenient grounds?
More lenient in the divorce bill, Your Honor. And it is more affordable and more expedient, Your Honor.
But the effect?
But the effects would be the same, Your Honor. The marriage would be nullified, Your Honor.
Then why is it,
Because
per
of
your view,
the,
why is it that many are opposing divorce?
because of the word divorce, Your Honor, we are not, perhaps because of our culture, Your Honor. In fact, when I learned about the divorce bill, Your Honor, I was thinking that the provisions there would be better if considered as amendments to the family code, Your Honor. So we will do away with the word divorce.
You just don't
In
like
fact-
the word divorce?
Yes, I think, Your Honor, because of our culture. But the grounds, there could be also grounds for declaration of nullity.
Now let's go to
or
the-
annulment of marriage, Your Honor.
Okay, well, let's just go to the annulment of marriage in church. Which is more lenient, that of the church or with our civil courts?
Our civil court, Your Honor. It
More
is
lenient?
difficult to get a church divorce, Your Honor. Church annulment, Your Honor.
Is that right?
I was told, Your Honor.
It's easier to get
I have not experienced that, Your Honor.
It's easier to have your marriage annulled in the church. Well, it's difficult, more difficult in our civil courts. Okay. Telehearing, which is a brainchild of Court Administrator Jose Maidas Marquez, has been the subject of public opinion before. Now, according to the proponent, said telehearing method would somehow address jail overcrowding, decongest court cases, and result in a speedy disposition of cases. Do you think this innovation will bring difference as to the acceleration of court processes, and why? Justice Cruz?
You refer, Your Honor, to a telehearing.
Yeah, telehearing or teleconferencing.
To my mind, Your Honor, I've been a trial judge for 10 years. There would not be much of a difference. Disposal of cases lies with the judge. If the judge is industrious, he manages his docket well, you do not have televisioning to dispose of your cases. But I would agree to that AM matter with respect to cases of involving national security and those where the accused is suffering from a disease. Those are instances where probably teleconferencing hearing may be had, but not the normal cases that are heard in court.
Okay, thank you. What is the principle of sovereign equality of states? Deputy Commissioner?
Sovereign equality of states. There is no states are equal, and one cannot invoke supremacy over the other, and each one has a sovereign rights over sovereign authority, power over its over the state, Your Honor. That simply means equality among the states.
Okay. Now differentiate subjects of international law from objects of international law. Justice Singh?
Your Honor, if I recall correctly, the subjects are the different states and the citizens of these states, while the objects are the respective properties or territories of these states. I'm not so sure.
Okay, Justice Garcia. Differentiate state of insurgency, rather. State of insurgency from state of belligerency in international law. Insurgency, belligerency.
I think state of insurgency is limited. It's national in scope within the same country. Public uprising for the purpose of overthrowing the government or removing its allegiance from the government. While state of belligerency is there might be external factors involved, like another country trying to invade, or even within the state, but for the purpose of delivering the state to another state, Your Honor.
Do you know what the data controller is under the Data Privacy Act, Justice Cruz?
The data controller, Your Honor, would refer to what is the contents of the computer. That is supposed to be handled with care, and that is not supposed to be exposed to those who are not authorized to see it.
Let's go to foreclosure cases under the General Banking Act. A corporation seeks a loan from a bank, and because of non-payment of its obligation, the loan was foreclosed. And this corporation wanted to redeem the properties. What is the period of redemption in this particular case? Deputy Commissioner?
1 year, Your Honor.
1 year.
From registration.
Would you agree with her, Justice Singh?
Your Honor, if the foreclosure is under Act 3135, then it's 90 days.
90 days.
Yes, from the date of the certificate of sale or the registration, whichever is earlier.
Justice Garcia?
Under the old law, Your Honor, it did not distinguish within
Under the General Banking Act of 2000.
The present law now states that if it is an extrajudicial foreclosure, the corporation has limited time within which to redeem the property. That is from the moment the bank registers the certificate of foreclosure, but not beyond 3 months, Your Honor.
Justice Cruz?
The rule is that a period of redemption is 1 year from the date of registration of the certificate of sale. But there is a Republic Act lowering the period of redemption involving, I think, banks and corporations where the period of redemption was reduced to 3 or 90 days, Your Honor. 3 months or 90 days.
From what?
From the date of the registration of the certificate of sale.
Yeah, under the General Banking Act, foreclosure of cases respecting corporations and other entities, the redemption period is 3 months from the annotation of the certificate of sale. And for the individual, still 1 year. Now, what is the amount that should be redeemed? Shall it be the amount bided at the foreclosure sale, or shall it be the total indebtedness, total liability rather?
I think, Your Honor, the law says that it should be the total indebtedness.
You agree with Justice CRUZ, Justice Garcia?
The law says, Your Honor, that the redemption price would be the total amount of indebtedness plus interest and cost, Your Honor.
How about you, Justice Singh?
Your Honor, it's the total amount of the indebtedness, interest, plus the expenses for the foreclosure.
Deputy Commissioner?
Your Honor, indebtedness plus expenses, cost of foreclosure, Your Honor.
So it's not the amount that is tendered during the auction sale by the sheriff.
No, Your Honor, it's the indebtedness, the loan.
The total debt is, okay. You're all correct.
Plus cost of foreclosure.
Are you in favor of reviving the death penalty? Deputy Commissioner?
No, Your Honor, because
Why?
there is no scientific or statistical data which
The
would
science
show
need to be
no
injected into it?
statistical data, Your Honor, that would show that death penalty indeed reduce the number of crimes.
Of
Reduce the number of crimes.
crimes.
Yes, Your Honor.
Why did you say that?
There was no such report, Your Honor.
So
In fact,
supposing if
that's
we
one
have
of the arguments for the
if we have
position.
the death penalty
And
and every day we execute convicts in the death row, will it not reduce the crimes?
And I don't think
committed?
the imposition of death penalty will solve the issue, Your Honor. It will. In reality, Your Honor, we couldn't say that all the accused are guilty, Your Honor. In fact, it is just a fact, Your Honor, that there are accused who cannot afford the services of more efficient lawyers, and they ended up convicted, Your Honor. So not all accused are guilty, Your Honor, in the same way that not all accused convicted and charged of a death penalty could be the real culprit, Your Honor. So we might be doing an injustice, Your Honor.
Will you be in favor of the death penalty in reviving the death penalty, Justice Singh?
Your Honor, I'd have to say that I'll have to agree with Director David because, well, number one, there's no proof that it acted as a deterrent while it was in effect. But the real reason, Your Honor, is that because our penal and correctional system is founded on the principles of restorative justice, and we believe that that is why we call it the Bureau of Corrections, because institutionalizing the accused who have been found guilty through the system of corrections that we have here means that we still hope that there is valuable human material there that can be redeemed and reformed. And that is why if we institute the death penalty, it's as if we're going the exact opposite of that fundamental principle of our correction system, Your Honor.
While being a trial judge before, have you ever experienced a case wherein the accused is the father and the victim is his minor child of rape?
Yes, Your Honor, many times, because when my pairing court, at the time judged by, who was handling a family court, retired, I acted in this court for a year until there was a replacement. And so there were many instances of incestuous rape, Your Honor. How
did you feel?
I felt terrible, Your Honor.
You wanted to kill the
not
the
to
father?
kill him myself, but to just say there should be no more trial. So tempted to say that, Your Honor. But then, even in the Court of Appeals, Your Honor, I just decided a case, an appeal, where a whole family was massacred, Your Honor. Their heads, including 2 minor children. One was a 6-month-old baby. And so when you come across cases like that, it's really terrible, and you feel that no amount of punishment or no length of time in prison will compensate for what was done, Your Honor. But then that is why I think the reinstitution of the death penalty is an appeal to the emotion. It's addressing a very emotional issue, and when we legislate and when we interpret the law, we should set aside emotions, Your Honor, and really think, is the death penalty the answer to the problem?
Your take on this, Justice Garcia?
Your Honor, I'm very much in favor of the imposition of the death penalty. I've been a public prosecutor for 18 years in the Department of Justice. So I have been a witness to a lot of cases involving heinous crimes, unimaginable, practically falling under the definition of heinous crimes, hateful, grievous. It will serve as a deterrent to the citizens not to commit heinous crimes. Anyway, the Constitution only allows the imposition of death only in heinous crimes as may be provided by law. And with the advent of the GCTA, or the Good Conduct Time Allowance, if you will only compute the maximum service sentence or imprisonment of reclusion perpetua of 40 years, if one is entitled with the good conduct for the past 20 years that he has served, that will entitle him to 18 years of good conduct. So 40 minus 18, he will just practically serve 22 years, regardless of the number of crimes that he was sentenced. And coupled with the new good conduct of teaching, study, and mentoring, entitling him to another 15 days per month, he will be entitled to pre-service of more than half of the sentence, Your Honor. And this will actually serve as an example to all the citizens not to commit any crime, especially to foreigners. In fact, drugs, illegal drugs, have been the transshipment port of the Philippines. The traders knowing that they can easily get away because the penalty is only imprisonment.
Justice Cruz?
I have 3 reasons, Your Honor, why I do not favor the reimposition of the death penalty. First, I view human life as important than the grievousness of the offense. Second, it has not been proven, that penalty has not been proven to be a good deterrence to the commission of a crime. And thirdly, our judicial system, and I guess any judicial system for that matter, anywhere in the world, is not infallible. There is still error, 1% or 2%, that the death penalty that is imposed is wrong. But then again, as Justice Garcia was saying, the Constitution does not prohibit the imposition of or the revival of death penalty. And this could be in heinous offenses, in heinous crime. Judges normally would follow what Congress thinks what is right. That is what we do. If it is imposed, then we will have to abide by it. But then again, I guess there must be solution as to how to lessen wrong imposition of the death penalty.
Thank you. That was my last question. And Good afternoon to all of you. Good luck. Justice Mendoza.
Thank you very much, Judge De Monteverde. Justice Tiham.
Thank you, Mr. Chairman. Good afternoon, Your Honors. Are you ready to join the Supreme Court? I heard that it is the dream of all lawyers to become judges, for all judges to become justices of the Supreme Court. I just hope it does not become the nightmare of people. Can you explain why some people call the Supreme Court the weakest branch of government? Deputy Commissioner David, the weakest branch of government.
Supreme Court or the Supreme Court power is also interpret. Yeah. We interpret tax law. Sorry, Your Honor. The executive department appears
The
to be the
Supreme
highest.
Court is the
The weakest
judicial
of all the-
department. Why is
the
it
three
considered
departments.
the weakest branch of government?
Because I believe, Your Honor, it's the weakest because of all the three branches, it appears to be the not the most I get lost, Your Honor. I don't have idea, Your Honor.
Justice CRUZ, what is your understanding? Why it is called the weakest branch of government?
The Supreme Court or the judiciary for that matter, Your Honor, is the weakest because it does not have the power of the purse, unlike the legislature. It does not have the army, unlike the executive. What it has is persuasion through the writings that it issues.
Justice Singh, some sectors also call the Supreme Court as the dangerous branch of government. What could be the explanation for that?
Well, perhaps, Your Honor, it's particularly because of the expanded power of judicial review, because with that power, Your Honor, the Supreme Court can review acts of both the executive and legislative departments for grave abuse of discretion. And
So
so,
why is it dangerous?
because the Supreme Court can nullify the acts of the executive and the legislative if grave abuse of discretion is found to exist. And therefore, in that sense, the Supreme Court has that power, which can be dangerous to the two other branches of government.
Do you think that is the motivation why many justices would like to join the Supreme Court?
Not really, Your Honor. I don't think so.
Justice Garcia, who presides in the Supreme Court and bank?
Your Honor, the Chief Justice presides over the deliberations in the Supreme Court.
Who records the actions taken by the court and bank?
Since the internal rules of the Supreme Court makes the deliberation confidential, neither any officer of the court except the 15 incumbent justices are allowed inside the room. I would surmise that each one has to take his own notes, especially the ponente and
Who makes the official Who is the official recording secretary of the Supreme Court and Bank?
Since it is confidential, Your Honor, there's no official record, I guess.
They just rely on their memory?
No, with the notes, Your Honor.
The Chief Justice who takes notes of the... What is an RA in the Supreme Court? What is an RA? Letter R and letter A. What is an RA in the Supreme Court? RA. Letter R and letter A. What is an RA? You should know about this if you're joining the court. Recommended action, okay? So when you read a particular decision assigned to you, you circulate it to the other members of the court, then you have a RA, or the recommended action. Deputy Commissioner Cui David, is it better to be in the majority when you vote or in the minority in the Supreme Court? I'm asking for your personal
Majority
opinion
vote.
because it is not in the internal rules.
Well, I believe, Your Honor, it is always better if you are in the majority vote because you will have the vote of the majority. You join the majority.
The voting is reckoned adopting the rule of the majority, correct?
Yes, sir. Majority, that's the majority rule.
There are 15 justices in the Supreme Court. If the voting is 7-7, what is the effect of that?
In case of in case of a tie, Your Honor, and in favor of the constitutionality of the law, Your Honor.
Is the Chief Justice compelled to break the tie?
The Chief Justice has also the right to vote, has also to vote, Your Honor.
The vote is 7-7. What is the effect of that?
Then there is a tie. The Chief Justice has to.
What is the effect of that on the petition submitted before the court?
Okay, if the decision is, in case it's a decision, Your Honor, and there is a tie, you follow the decision, Your Honor. You do not. You have to follow the decision, Your Honor.
You grant the petition or you
grant
dismiss the petition?
It's if the decision, it's the granting of the petition, Your Honor. Now, if the issue is about the constitutionality, then in case of tie, we uphold the constitutionality of the law.
Normally, a petition is filed in the Supreme Court to assail the constitutionality of a law.
Your Honor, yes.
All right? If the vote is 7-7, what is the effect
We
of that?
uphold the constitutionality of the law.
Justice Singh,
Yes, Your Honor.
supposing the vote is 7-7, the vote is 7-7, and they voted already,
Yes, Your Honor.
and the decision was circulated to the members, can a member change his mind? If he is, for example, in 7 to grant the petition, can he change his mind, change his vote to deny the petition before it is promulgated?
Well, I think, Your Honor, it has been stressed over and over that the Supreme Court acts as a body, as a collegiate body, and everything is reached in consultation. All the decisions are reached in consultation. So your vote during the deliberation should bind you already, and your colleague should be able to hold on to that and rely on that already. So if you vote for or against during the deliberations. You cannot simply change your vote when the decision is already being routed to you for signature, Your Honor. At least that's my belief.
Garcia, do you agree? Can you still change your vote before it is ultimately promulgated?
I don't think so, Your Honor. Under the Supreme Court internal rules, if there's a reflection or dissent on the submission of the ponente, there's a time frame for you within which to submit your reflection. So after the deliberation, everybody has already voted. It is the time that the ponente or the one who will write the decision is assigned. So for purposes of expediency and to avoid any sense of irregularity, your voting on during the deliberation is final and conclusive, Your Honor.
Justice Garcia, supposing the voting is 8-7, it's a close vote. Can somebody who voted in the majority change his mind to vote to the other side so it becomes 7-8? After the voting, after the deliberation and bank, but before the promulgation of the decision?
Your Honor, my view is that until a decision is promulgated, there is no decision yet. So much so that even if the bank or the division has already voted on an issue, anybody could change his mind until a decision has been promulgated.
Is there such a thing as a gentleman's agreement on the result of a voting?
There is a gentleman's agreement, Your Honor, but then justices also change their minds.
Is it proper to reverse a decision rendered by the Supreme Court a year ago when there are new justices like yourselves joining the court, when the ponente and the others a majority of those who concurred are still in the court? Is it proper?
Your Honor, there is this principle of stare decisis, that for purposes of stability and consistency, matters that have already been decided remains decided.
U.S. Supreme Court, they have this rule of 4 or rule of 5, wherein a matter of tradition, the justices do not reverse a decision, even though it's erroneous, so long as the majority of those who voted in favor of it are still incumbents or still in office. Deputy Commissioner David, what is the apostille convention?
That is the first time I heard
That
about
was
that one.
asked by Judge de Monteverde earlier. He did not characterize it, but he asked you that question.
I did not quite.
Simplifying authentication of public documents used abroad. That is the apostille convention. Justice Singh, what is the second protocol of the International Convention on Civil and Political Rights?
Your Honor, I believe that has to do with the non-imposition of the death penalty. The member states are encouraged to abolish any the imposition of the death penalty, Your Honor.
Is the Philippines have we acceded to that second protocol on the International Covenant on Civil and Political Rights?
Yes, Your Honor.
Why did you not mention it when you were asked whether you were in favor or against the death penalty?
Well, I believe, Your Honor, I was being asked for my opinion on the reimposition. So I gave my personal reasons. Besides, Your Honor, I guess the next question would be, if we do not comply and reimpose the death penalty, would there be sanctions?
You read my mind. That is my next question.
Would there be sanctions?
If we reimpose the death penalty, are we in effect reneging on that second protocol?
Well, yes, Your Honor, because we acceded to it, but then the question then
Is
would
that a
be,
legal impediment for us to reimpose the death penalty?
well, Your Honor, if we want to maintain our stature in the international community, then we should honor our international commitments. Otherwise, Your Honor, the other states we deal with would not have the same level of trust and confidence in us if we renege on our international obligations.
Justice Garcia, who are the 3 Supreme Court justices who went to The Hague to accede to deliver the instruments of accession signed by President Duterte, acceding to the Apostille Convention? Can you make a guess? 3 justices of the Supreme Court.
Your Honor, Justice Leonen, Gesmundo, and yourself, Your Honor, Justice Tia.
Did I tell you
Yeah.
about it?
There was a time I dropped by your office and you were in Netherlands, all of you at the same time.
All right. Justice Cruz, is there res judicata in criminal cases?
There is none, Your Honor, because once an accused...
There is res judicata in civil cases.
Yes.
But in criminal cases, is there res judicata?
In criminal cases, in the event of an acquittal, that is a period to the case. And if a period is convicted,
Have you heard about res judicata in prison grey, Grey? What is the equivalent of that?
I really could not
That's
assess it.
double jeopardy. That's the equivalent in criminal cases. What kind of a magistrate would you be, Justice Cruz, if you joined the Supreme Court? Are you a leader or a follower?
I think I will have to be a follower. I will have to follow what the Constitution dictates
Follower.
and what the evidence tells me to do. That's it. It is a mere follower.
How can you effectively deliberate on cases if you just follow
It is a matter
the
of...
opponente? And
Yes, Your Honor. It is a matter of convincing your colleagues that your ponencia is in accord with the Constitution. It is consistent with the facts. It is what the evidence says.
will you be obeying everything that your senior associates would be telling you to do?
No, Your Honor, of course not. I have my own mind.
Justice Garcia, are you assertive or accommodating?
Both, Your Honor, assertive in the sense that I have to show my leadership because more than half of my career of 39 years in government service, practically I was either the head of office or next in line. But accommodating in the sense that I am a team builder. Once the majority have decided in a particular case, I have to abide by it, even if I lost in the vote.
Will you concur with Justice Esmundo, for example, because he is your friend?
Personalities have no relation to my decision making, Your Honor. Friends or foe, I look at the merits of the case and the facts. In fact, even when I have decided cases, I don't even know who the lawyers are. I don't look at the last page. I don't look at the relationship or whatever to influential people. So my mind is focused on strictly on the facts and the laws applicable, Your Honor.
Justice Monet, are you active or passive person?
I have to admit I'm always active, Your Honor.
Are you eccentric or phlegmatic?
I'm neither. I'm in the middle, Your Honor. I'm not eccentric, although some of the people who really know me may say I'm odd in some of the things that I do, Your Honor. But as a member of the court, I'm neither. I think I'm in the middle, Your Honor.
Deputy Commissioner Cui David, have you heard about the word Gilbert? What's a Gilbert in the Supreme Court?
That is also the first.
Is it a person?
Gilbert, Your Honor.
Gilbert.
First time to hear about that, Your Honor.
About reflections. What are reflections?
Your image. Image.
You're talking of a mirror. Reflections.
What you see what you see of yourself.
As a written instrument, what are reflections? Reflections in the court. What are those? Dissenting opinions. Those are dissenting opinions. Justice Cruz, what are advisories?
Advisories are news that is issued by the court to guide the public or advice opinion that is given by the court for public consumption.
It is the agenda to be followed during oral argument. That's advisory. What do you mean, Justice Garcia, of door to door? I'm not talking of the pizza delivery. Door to door.
I guess, like in our office, once you route a decision in a sealed envelope, meaning only for the eyes of the member justice in the division, it is delivered straight to the office or door of the justice concerned to preserve confidentiality, Your Honor.
Several years ago, a justice of the Court of Appeals was disciplined because it was established that he went to another member of the division to personally bring the decision, the final decision for signature on a door-to-door. Was that something unethical? And why was that Court of Appeals justice sanctioned by the Supreme Court?
Perhaps it's extraordinarily isolated or anybody's attention would be called, because normally after we sign the recommended or draft decision for routing, we leave it to the Secretary and Utility to release the sealed envelope of our decision. It is manifestly unethical for the justice concerned to go to the member justice, because the impression is you are interested in that particular case, Your Honor, and there's no other conclusion than that.
Justice Monette, what is your understanding of the Bill of Rights relating to freedom of religion?
Well, Your Honor, the freedom of religion provision partakes of two clauses. The first is what we call the free exercise clause. Every individual is entitled to the free exercise of his or her chosen religion.
Can a judge or a justice of the court refuse to recite the centennial prayer?
Yes, Your Honor. Yes, Your Honor, under the free exercise clause.
But that is a tradition, a practice of the court, to recite the centennial prayer before the start of the session in court.
Yes, Your Honor, but there are those who may not believe in praying or in any supreme being, Your Honor, and in that sense...
Can an agnostic be appointed to the court?
Yes, Your Honor, because religion is not a qualification under the Constitution.
So when he takes his oath of office, there's a provision in the oath of office, so help me God. Is he allowed not to say, so help me God?
Yes, Your Honor. I
Why?
believe so, under the
Why?
free exercise clause, Your Honor. Because he does not believe in God. He takes his oath and gives us his word.
Does moral belief, this was asked earlier, does moral belief play a part in the decision-making process?
I believe so, Your Honor. We are guided by our own values in decision making. That is our guide. Although, of course, the law is what we're interpreting.
So you should listen to your own moral, personal conviction before deciding a case.
No, Your Honor, because I think it is Holmes who said that all law is based on morals, and the foundation of law is morals. It's the moral consensus in a given community which gives rise to a set law or rule of conduct. And so it is important that we take into consideration these moral moorings of our laws when we discharge our adjudication duties, Your Honor.
Are you familiar with the case of Escritor?
Yes, Your Honor.
Who penned that decision?
Chief Justice Puno, Your Honor.
And what is the pronouncement in that decision?
Well, Your Honor, the protagonist there was sued administratively for immorality, and her defense was that her religion, I forget, I think Jehovah's Witness, Your Honor, her religion does not adjudge her immoral. The conduct, her relationship with the man was not in their religion condemned as immoral. And so she could not be sanctioned for that particular conduct and removed or dismissed from the service by reason of it. And the court sided with her, Your Honor.
Does it not infringe on the equal protection under the law as it elevated members of the Jehovah's Witnesses on a different plane than people in other religions?
I don't believe so, Your Honor. I think, in fact, it is a testament to the fair application of the Equal Protection Clause. We've had other decisions favoring members of other religious organizations or sects, Your Honor, not just the Jehovah's Witness. I believe we accommodated the Seventh-day Adventists by excluding them from work on Saturdays because they are not allowed to work on Saturdays. And we also have days devoted to our Muslim brothers and sisters when they are fasting, Your Honor, when they are allowed to work only from 7 to 3 p.m., Your Honor, in view of the fact that by that time in the day they are already very hungry and do not have the energy to work, Your Honor. So I don't think so, Your Honor.
Do agnostics have moral religious convictions?
Moral convictions, Your Honor, but not religious.
Where do they derive their sense of right and wrong?
Your Honor, like I said earlier, the morality it begins with the general consensus in the community about what is right or wrong. And that is how rules of conduct, the laws that we have now, have evolved into being, Your Honor.
There was a case of a teacher in an exclusive girls' school. I'm addressing this now to Deputy Commissioner Cui David, who was single, who was engaged to be married. But unfortunately, her boyfriend abandoned her and married somebody else. It was not her fault. She was abandoned. And the school found out that she got pregnant. It was not really her fault because she was about to get married, but the boyfriend backed out. And the school wanted to ask her to resign from school because of the school manual on good conduct for teachers and school personnel. Is there just cause to ask her to resign?
Yes, Your Honor, because the schools, they have the academic freedom, Your Honor. And under this, Your Honor, the school can determine for itself who can taught, Your Honor, in the school, who can teach. So the teachers and the administrative staff the school has
Is
discretion.
the woman entitled, is the girl teacher entitled to damages because there is constructive dismissal? She was asked to resign, she did resign, but later on she filed a labor case against the school. The school invoked academic freedom. What is academic freedom, by the way?
Academic freedom is the right of the school to determine for itself on academic grounds who can teach, what subjects to teach, and the manner of teaching, and who shall be admitted, meaning the students, Your Honor. Now, with respect to the question on the constructive dismissal, I believe, Your Honor, that that employee can lodge a labor case, Your Honor, and she can be awarded damages, because even if the school has the academic freedom, it is not it is still duty bound to apply due process, Your Honor, in terminating its employees.
Justice
So
Cruz,
notice and hearing, Your Honor.
under the Universal Declaration of Human Rights, do terrorists have human rights?
Yes, Your Honor. But they are terrorists, but still they have human rights. They're entitled to respect for human rights. The trouble is,
Have you read the Universal Declaration of Human Rights? So terrorists who cause injury and death to fellow human beings have human rights?
Yes, because they would be entitled to due process.
I'm talking about human rights. Do they have human rights?
My personal view, Your Honor, is still they have.
If the CPP-NPA is declared or has been declared by the government as a terrorist organization, can that be a basis for seeking the extradition of or cancellation of the asylum of Jose Maria Sison in the Netherlands?
If he continues to ascribe with the ideas of communism, that could be a ground for his extradition.
Is the Communist Party of the Philippines a subversive organization?
I think as of now it is not,
Why not?
because there is no law treating it as a subversive organization.
Because the anti-subversion
Has
law
already
has
been amended.
All right. Justice Garcia, what is your understanding of the doctrine of hierarchy of courts? Hierarchy
Hierarchy of courts, Your Honor, even if the rules allow remedies to different courts from the Supreme Court, appellate, or regional trial court of concurrent jurisdiction, the petitioner should go first to the lower court where there to ventilate disputes and settle disputes concerning trial matters of facts, instead of going straight to the court or appellate court. That is respecting the hierarchy of courts, Your Honor.
Why does the Supreme Court consider the doctrine of hierarchy of courts as a filtering mechanism?
Your Honor, some litigants make a shortcut of the procedures. They go straight to the Supreme Court, invoking novel question of law, or the issue is of transcendental importance. That's why jurisprudence dictates that when the determination of the issue involves questions of facts, it should go first to the lower court, because the Supreme Court does not entertain questions of facts, but limiting itself only its jurisdiction to questions of laws.
Can
Your
you
Honor.
think of one example where the Supreme Court is specifically vested by the Constitution to consider questions of facts?
The declaration of martial law, Your Honor, the Supreme Court is, because before the EDSA 1, the Supreme Court in most cases dismissed cases on the ground of political question. So that's why the Constitutional Convention, which drafted the 87 Constitution, inserted or provided this provision in the Constitution that in case there's a declaration of martial law by the President and concurred in or not objected to by Congress, the Supreme Court can nevertheless entertain petition assailing its proclamation, including questions of facts if there is basis for such declaration, Your Honor.
Justice Monette, in the case of Republic versus Provincial Government of Palawan, this is the Malampaya case. In the case of LGUs, local government units, to what does the territorial jurisdiction extends? Does it include areas beyond the land mass of LGUs? Territorial jurisdiction.
Territorial jurisdiction. No, Your Honor. The territory is limited to its landmass.
And if it exercises jurisdiction outside of the landmass, like fishing
What?
rights, things like
Oh,
that,
the waters.
The
Oh, yes,
waters.
Your Honor.
is the province of Palawan entitled to a share in the revenue of the Malampaya?
I have to admit, Your Honor, that I did not read that case. But from what I've read in the papers, that was the very bone of contention in the suit, that they claimed that they should be given a portion of the income or the revenue from that.
So was the province of Palawan given share?
Yes, Your Honor.
That's in the newspapers?
Well, that's my recollection, Your Honor. It was not this year. I believe it was
Do
several
judges
years ago.
have to take judicial notice of newspaper accounts?
No, Your Honor. No, not of judicial, not of newspaper
It's
accounts, but of the
preferable-
decisions of the
It's preferable
court.
to read the decisions
Yes,
of the
Your
court.
Honor. Yes, Your Honor. That is ideal.
Deputy Commissioner David, I know that your expertise is in taxation, commercial law, and matters pertaining to finances, but do you have any working knowledge of international law? A little?
Honestly, Your Honor, I did
So
not practice
if appointed to
international.
the Supreme Court, will you be telling the Chief Justice that you can only handle tax cases and commercial cases? Is that what
No,
you
Your
plan
Honor,
to do?
I always crave for knowledge, Your Honor, so if given the chance, I have to make further
Because
studies of
if
this
you're
law.
applying for a position in the Supreme Court, you cannot do on-the-job training.
Yes,
yeah?
Your Honor.
You won't have that time.
In fact, Your Honor, when I joined the Bureau of Internal Revenue, I know nothing about technology, Your Honor. But then I had to undergo series of trainings and further studies to know the craft. So I can also do that in the Supreme Court.
All right, one last question. Justice Moncruz, what is the quantum of evidence in criminal cases for conviction, proof of guilt, beyond reasonable doubt? Drug cases.
Still,
Okay.
proof beyond reasonable doubt.
And during the pretrial conference, the prosecution and the defense were asked to lay their cards on the table, and they presented their evidence. And it was evident that there was proof of guilt beyond reasonable doubt. And yet, because of certain decisions of the Supreme Court, if there was a non-compliance with the chain of custody rule, this evidence were made inadmissible. What will happen to the accused, acquitted?
Well, an accused, Your Honor, who made who enters into some stipulation of facts during the pre-trial.
Now, the chain of custody rule was violated,
But I would guess that during the pre-trial,
so the evidence will be declared inadmissible.
if I would suppose, Your Honor, that during the pre-trial, the admission extended to the chain of custody. If that extended to the
Supposing the
custody,
chain, the break in the chain of custody was discovered during trial when the prosecution witnesses started to testify on cross-examination, and it was discovered that there was non-compliance.
Then
There was
I-
a deviation from the chain of custody. So necessarily, the evidence was set aside. And what will be the effect of that? Acquittal?
acquittal, I guess, Your Honor.
In spite of the fact that during the pretrial conference, it was evident that there was proof of guilt beyond reasonable
Yes, Your Honor,
doubt.
please. I guess the accused would deserve an acquittal.
Is it just?
The problem was on the prosecution. We should have stopped establishing that evidence because anyway, it has already been stipulated upon.
Justice Garcia, can you cite some provisions in the revised penal code which are coercive against the accused, but are not considered penalties? Can you think? Coercive,
Revised Penal Code, Your Honor.
yes, but they're not considered as penalties.
The accessory penalties, Your Honor, in case of conviction of a public officer.
Detention as a result of insanity, imbecility, illness, they're not considered as penalties, correct? Commitment of a minor. Is a curfew ordinance constitutional?
Curfew.
Curfew ordinance?
Yes, Your Honor. Under the police power, regulatory power of the local government, and on the other provisions to promote.
What about the curfew ordinance imposed by your spouse?
That's an heinous crime,
That is
Your
more
Honor.
coercive. That is more coercive. So it's valid, it's constitutional. But in one case decided by the Supreme Court, which was penned by Justice Bernabe, the Supreme Court declared the ordinance in Manila
Excuse me.
unconstitutional, but the other ordinance in, I think, Navotas, constitutional. You better read on that, on that provision. Justice Singh, what do you understand by stealthing? There was a...
Yes, Your Honor, I read about this.
There's a bill filed in
Yes,
Congress.
okay, so
Which considers it as tantamount to sexual assault or rape.
yes, Your Honor, my understanding is that there is a consensual, there's consensual sexual relations, but then the one partner requires the use of a condom, but the other partner removes it without the knowledge of the partner who insists on the use of the condom. That's stealthing.
I think it's a valid law if passed.
Your Honor, from what I read, that they are classifying it as sexual assault or as a type of rape, Your Honor. But then I was thinking that rape, at the very core of the act of rape is the non-consensual nature. And so here, the foundation is that there is consensual sex, Your Honor. It's just that one party insists that we use a condom. But then the other party does not tell him or her, does not tell her that they are removing the condom. So there is consensual, there's consensus or there's consent to the rape, to the sex act, Your Honor. So I have trouble reconciling that and classifying it as an act of rape, Your Honor.
Yesterday, Justice Mendoza asked this question, and I addressed this to Deputy Commissioner Cui David. What is the crime of economic abuse? Have you heard about it? So this is somewhat related to finance, economic abuse.
Sabotage. I only, this is also the first time that I heard about that, Your Honor.
Respect to support.
Support.
Not talking of infrastructure support. Our husband and wife, are the husband and the wife obligated under the civil code to support each other? And if there is refusal to perform that legal obligation, what crime is committed by the husband?
Failure to give support, Your Honor?
Yes. Is that economic abuse?
Because
That's a leading question.
it appears, Your Honor, that that is an economic abuse.
It's an
because
economic
that is
abuse.
Financial.
Okay, that is my last question. Okay, thank you and good luck to everybody.
Thank you very much, Justice Tihan.
All right.
Judge Ila will be the next interview.
Before I start, I have one consolation given by the council to request a break for the applicants. Yeah, you can relieve yourselves, ladies to retouch, gentlemen to detach. Let's have a break, Mr. Chair.
3 to 5 minutes. Okay.
the interview, Mr. Chair. Yes, thank you. All right, good afternoon, Your Honors. We just have to trust a few questions, considering that you have underwent extensive, exhaustive interviews. All right, can we start with the Justice CRUZ? How have you embodied the principle of integrity in your entire legal career? How many cases did you have, administrative cases, starting when you were still a presiding judge of the lower court?
So I would start, Your Honor, from the time I was appointed RTC, because you were saying that the stretch would be the entire legal career. But I was appointed RTC judge in 1999 until 2009. In so far as administrative cases, the administrative cases which were lodged against me did not touch on dishonesty, corruption, or something which would touch on integrity. It mainly deals with the decision which I issued were wrong. So I would say that in matters of integrity, for almost 20 years now that I've been in the court, that has not been put in issue.
And per records, you had been a member of the technical working group on the continuous trial, as
Yes, Your
well
Honor.
as the amendments, proposed amendments in the civil procedure. So what, if any, do you wish to change in our judicial system or process? Yes, aside from the continuous trial as well as in the civil procedure.
I was asked earlier by Judge De Monteverde on death penalty. There is now a clamor for the reimposition of death penalty.
Death penalty in
Yeah.
civil procedure?
Yes, no, it's in criminal procedure.
Criminal procedure.
I was thinking that if ever it is reimposed, there should be a requirement that before the decision is promulgated, that the prosecution must be tasked to prove anew the existence of aggravating circumstances and that there are no mitigating circumstances. That way, we lessen incorrect decision touching on death penalty. That is not yet in the rules, but I guess that could be looked into.
All right, so other innovations that you have?
In civil procedure, Honor, there is this rule on annulment of judgment. Basically, it is an equitable remedy. That is not found in criminal procedure. I guess we could work out on this, by, especially in those cases where the impossible penalty is reclusion perpetua or in the near future death.
How quickly will we see results from your appointment in relation to the innovations you think of?
It will depend, Your Honor, on the passage of the death penalty. If it is passed immediately, then I guess that is a proposal that could be looked into. Insofar as the availability of annulment of judgment in criminal procedure where the offense is punishable by, say, reclusion perpetua, I guess that will depend now to the Supreme Court and the exercise of its rulemaking authority.
All right, could you walk me through the steps you undertook to prepare yourself to justiceship to the Supreme Court?
I was a trial lawyer, Your Honor, for almost 20 years, RTC judge for 10 years, and by October in the Court of Appeals for another 10 years. As I was saying earlier, I did what I had to do. Out of ordinariness, I've been faithful to the causes of my client, did my cases within the timeline, opened my trial as dictated by the rules at 8:30 o'clock in the morning, and gave long hours to the cases assigned to me. It's as simple as that, Your Honor.
So what one skill makes you the most qualified for justiceship?
I do not claim any advantage, Your Honor. We are in the same boat. Some here, but especially those coming from the Court of Appeals, claim that they have a zero backlog. I have also attained that. We are tasked to do the cases that were assigned to us. So I do not really claim any advantage, especially those applicants coming from the second tier court.
And what excites you most about this position? What
Well,
are your expectations to the Supreme Court?
The Supreme Court, Your Honor, is the court of last resort. You handle all kinds of cases. Constitutional issues are there. The interplay between government agencies are matters for you to look into. You dialogue with, in terms of resolving cases with other government agencies. And the life, the liberty of the people are eventually or ultimately decided by that court. So it would really be a great honor to be in that position. Although it's really a great responsibility.
All right, Canon 2 of the Code of Judicial Conduct states that a judge, a magistrate should avoid impropriety and the appearance of impropriety in all activities. How have you embodied this requirement?
It is, Your Honor, yes. It is a matter of perception. I choose my friends. I deal primarily with my colleagues in the court, meaning that my core set of friends are not really that wide. Because I really avoid perception. Perception of doing that is bad and not inconsistent with our canons.
What is your take for those who like press conferences in media? There are magistrates who are fond of calling or holding a press conferences in media.
It is their call. But to me, I prone telling media my accomplishment. I do my work without fanfare, but with due care.
All right, have you read this in the matter of the alleged improper conduct of Justice Badoy, Junior 443, still Philippine Reports, 296-313. Judges are not actors or politicians who thrive by publicity. Publicity undermines the dignity and impartiality of a judge. Thus, at no time should be that he be moved by a desire to cater to public opinion to the detriment of the administration of justice. And it continues, this is the high price they have to pay as occupants of their exalted positions. All right, do you think that magistrates mingling with other personalities violates Canon 1 of the new conduct of judicial conduct?
If he mingles primarily with co-justices or co-judges, then I guess that it would be fair. But if he mingles with people who gambles, or people with characters which undescribable, then I guess that would be objectionable.
All right, what have you done professionally that is not an experience you would want to repeat?
There is this case, Your Honor, which I decided. It is an attachment of mine in my PDS. It was a case where the father, the man, was accused of parricide. He was accused of killing his wife and 2 children. He was a seaman. The case was assigned to me on appeal. He was convicted in the RTC. But the prosecutor and the judge did a sloppy job. So I acquitted him because that is what my conscience told me. That was what the law and the evidence asked me to do. But personally, I really hate that case because, you know, a father at that being accused of killing his wife and children. But because of a reasonable doubt, because there is no evidence really pointing him to be the killer, I have no other resort but to acquit him and reverse the RTC.
What would you do differently if you knew no one would judge you?
If no one would judge me, Your Honor, I guess there is some problem with the system.
What's the problem of the system?
Because for every layer, for every organization, for every activity that a man does, someone should be judging him. Someone must be looking at him.
If you had to choose to live without one of your 5 senses, which one would you give up?
I guess the sense of smell
Why?
is against the sense of sight and hearing. That is something that you could, the less that you could forego.
Regardless of what you see, you don't have to
That-
appreciate because you don't have any sense.
Sense
Smell?
Of, yes, Your Honor.
Alright, recently the Supreme Court in Tuates versus People reversed the ruling of the Court of Appeals and acquitted the accused, who was convicted by both the Regional Trial Court and the Court of Appeals, on the ground that there is reasonable doubt as to the possession of drugs of the accused. In that case, there were conflicting testimonies of the prosecution, and it turned out that the authorities did not comply with the directives of the Bureau of Jail Management and Penology Standard Operating Procedures, number 2010-05. Are you aware of this case, Justice Cruz?
I do not have a full grasp of the faction.
All right, Justice Garcia, you're looking at me so seriously. How are you today, Regalo? Still sporting that white hair, just like Sammy Martires?
Fine, Your Honor. Thank you.
Yes, say what is, have you read this case, Tuates versus People? Tuates, April 10, 2019.
Your Honor, we try to go over the recent decisions of the Supreme Court to guide us for the interview. But unfortunately, there are some cases like the one on the same-sex marriage. It's not even uploaded in the internet, Your Honor.
Justice Mon Garcia, how long have you been staying in the government service?
A total of 39 years, Your Honor. In the Court of Appeals, a total of 14 years, Your Honor.
Empirical knowledge of men teaches us that those who stayed in the government for so long has the tendency to relax or to reach such boredom. Do you agree with this?
No, Your Honor, not in
And
my
how
case.
young are you?
65, Your Honor. But I just turned 65. I still have almost 5 full years to serve in the Supreme Court if ever appointed. Going back to the question, Your Honor, length in the service of the government does not necessarily result in laziness or relaxation for familiarity of the routine work, Your Honor. In my case, Your Honor, all my functions and duties from the Solicitor General's office, which definitely there's no rest considering that all the time you have to write decisions, appear in courts, etc. As City Prosecutor of Manila, you're not only in charge of yourself, but all the 130 prosecutors submitting recommended resolutions to you. And in the Court of Appeals, for 14 years, all the raffled cases that are assigned to you, there's simply no time to relax. In like manner, if appointed to the Supreme Court, I am fully adjusted to that kind of work, Your Honor.
Would you rather lose all of your old memories or never be able to make new ones?
I'd rather be unable to make a new one, Your Honor.
And why?
At least in my 65 years, I have a lot of past not so good and fond memories, and intellectually wise also. If ever I lose or not be able to gain more knowledge, since the retirement age is 70, that would be lesser harm or the lesser evil, Your Honor.
What do you wish you had done differently in your life?
So far, Your Honor, all my actions, I'm grateful to have acted in this manner. I don't think I would have changed or acted differently in terms of major decisions in my life. Otherwise, I wouldn't have been here. But only that there was one thing in life as a lawyer that I wanted very much to do, and that was teaching after my law school. But after having gotten married, I was discouraged by my wife because it will eat substantial time in the family, considering the distance of my office from my residence, and at that time Ateneo had only night school, or even if they had afternoon school, it started at 5. So practically, if I ended up teaching, the earliest that I could go home during teaching days would be 9 o'clock or 10 o'clock, Your Honor.
All right, how do you handle a case being in a bad mood or difficult situation?
Your Honor, through my experience, from the OSG, DOJ, CA, the moods or other factors never entered into my mind whenever I decide cases. Once I'm tired, I have to rest. It has been my practice not to work on weekends, Your Honor, Saturday and Sunday. I acquired that good attitude when I talk to a priest telling me not to make my family or my house as an extension of my office, because that was normally the complaint of my my wife before we got married, she could see the time that I devoted in my office. So when I go to work from Monday to Friday, I'm fully charged, Your Honor.
Have you read the case of People versus Claudel?
Versus
GR number 219852, April 3, 2019.
on what matter, Your Honor?
Of an accused was convicted by both the RTC and the Court of Appeals for possession of illegal drugs in a by-bus operation, despite not having witnesses from the media and the barangay.
Conviction, Your Honor.
No disrespect to the required for the so-called saving clause to apply in relation also to People versus Lim.
I'm familiar with the Lim case, Your Honor. The Section 21 of 9165 of the Comprehensive Drugs case was amended as to the procedure in the chain of custody. Before there were three witness rule. Now they reduce it to two. Number one is the elected official, and the second is a representative from either the media or the DOJ. This is mandatory requirement. Although if they fail to satisfy that requirement, the remedy is for the arresting officers to execute an affidavit to explain or justify the absence of any one of the requirements, and for the prosecutor to cure the defect during the trial. In the meantime, many cases have been decided acquitting the accused for failure to comply with this requirement. Although there is a safety clause in the amended Section 21, but it's derived from the jurisprudence that notwithstanding with the failure to comply with this requirement, as long as the integrity and evidentiary value of the illegal drugs is preserved, nevertheless, conviction follows. But because of the mandatory requirement of the two-witness rule, in which was given retroactive effect, it resulted in a lot of acquittals, not only in the Supreme Court but in the Court of Appeals, Your Honor. It would have been better if, to my mind, the jurisprudence was given prospective application, because during those times, before the promulgation of this Lim case, the police relied on the jurisprudence that as long as the integrity and evidentiary value of the drugs, illegal drugs, is proven, there was substantial compliance with the requirement of Section 21, Your Honor.
What do you want to be remembered for, Justice?
A dignified judge of proven competence and integrity, with an unblemished record, Your Honor, notwithstanding my 39 years of government service. I've never been charged. In my 14 years in the Court of Appeals, not a single administrative case has been charged against me, Your Honor. In the office of the City Prosecutor of Manila, which I held for 10 years, 10 long years, but I have been charged in the Ombudsman as head of office for included among the handling or assigned investigating prosecutors 6 times only, Your Honor. And these cases involve only trespass to dwelling, grave coercion, falsification, and libel cases, meaning no money is involved, Your Honor. So my integrity and reputation, modesty aside, has been established, Your Honor.
Thank you, Justice Mon Garcia.
Thank
Yes,
you.
good afternoon, Justice Singh. How are you today?
Good afternoon. I'm fine, Your Honor.
You look more gorgeous today.
Well, thank you. Thank you, Your Honor.
The favorite of CJ. All right, what is something that no one would ever guess about you?
What is something that I am funny? I have a sense of humor. People normally don't think that of me. I think the general impression is that I'm a very serious person.
And how could you maximize technology and social media in the judiciary?
Your Honor, technology certainly, we need it. We need to step up. We've been left behind. The judiciary has been left behind, not just internationally, but also here. The other agencies and branches of government are already automated, but the judiciary is far behind in that aspect, Your Honor. It will help speed up our processes. It will also ensure more consistency in the processing of our cases, plus more transparency also, Your Honor, and accountability. So I think that is what we need to do in terms of technology, Your Honor.
What is your greatest failure? And what did you learn from it?
Well, Your Honor, I still think that I failed in the sense that my marriage failed, Your Honor. I am a solo parent and I raised my 4 children on my own. That being said, I'd like to think that I acquitted myself well in that regard. My children are good children, decent human beings. But if I consider it a failure, Your Honor, because I would have wanted them to have a traditional home where they had both parents. But at least, Your Honor, they had an entire family, my own family, as their extended family in growing up.
What do you have in common with your family?
Oh, many things, Your Honor. Love of family is at the very root of our commonality. We are all very devoted to each other, to our parents, and to our children. Our children grew up like they were brothers and sisters. So that is a very important anchor in my life, actually, Your Honor, in the lives of my children.
How do you take advantage of your strengths?
My strengths, Your Honor, well, of course, like any other person, if you know that you are strong in one aspect, you would use that to achieve more, Your Honor, and to help others also. So if you see people who are weak in a certain regard and you find yourself to be strong in that particular aspect, then you use that to help those people, reach the level that they need to reach so that you can be on the same footing.
And how do you compensate for your weaknesses?
Well, then I try to improve myself, Your Honor, as much as possible. If I find myself lacking in any regard, then I devote myself to improving in that aspect, Your Honor, until I feel more confident that I am no longer weak in that particular aspect.
What's the difference between the case of Estepona versus Lubrigo and People versus Romilim?
Your Honor, I'm not very familiar with Estepona. I am familiar with, is this the Romilim case, Your Honor, or a different lim?
People versus Romilim.
Romilim. Well, I'm very familiar with Romilim, Your Honor. Estepona, I'm sorry. I cannot say that I have read that case, or maybe I've read it, but so many drug-related cases, Your Honor. So I can tell you about Romilim, Your Honor, if you want.
About this case of Lagman versus Senate President Pimentel, February 6, 2018.
Your Honor, what particular subject, Your Honor?
The court had the occasion to rule on the power of Congress to extend and determine the period of martial law and suspension of the privilege of writ of habeas
Okay.
corpus.
Oh, yes, Your Honor. Okay.
Could you elaborate on this as
Well-
discussed in that ponencia?
Well, what I know of it, Your Honor, is that the original period for the declaration had already lapsed or was about to lapse, and so there was an extension, and that was the subject matter of the case, Your Honor, and there was an issue as to the constitutionality of extending it, Your Honor. Again, there had to be an examination of the factual basis, as with the original declaration, Your Honor, for an extension. And so the court found that there was still factual basis, despite the fact that the incident in Marawi had improved, but that there were other pockets of aggression that convinced the court, Your Honor.
About this case of Tuates versus People, GR number 230789, April 10, 2019,
Your
penned
Honor,
by Justice Kagiwa.
Your Honor, the case of Tuates involved a body search at the corrections facility. Tuates was visiting her boyfriend, Your Honor, who was detained in the penitentiary. Now, Your Honor, this involved a search where the jail guard made Tuates lift up her blouse, Your Honor, to check for contraband. And so this was found to be invalid, this search, and so the evidence was inadmissible, and which resulted to her acquittal. It was found to be invalid, Your Honor, the search, because apparently there are very specific rules in the corrections facility for the conduct of body searches. First, there has to be a pat and frisk, Your Honor, and only if there is probable cause on the basis of the pat and frisk can there be what you call the rub or squeeze test, and eventually the most invasive, which is the body cavity search, or search of an orifice of the person, Your Honor. And here, the court found that there was no probable cause for the lifting of the blouse of Tuates, because the only reason that the jail guard gave for conducting that kind of or type of search was that Tuates was visiting an inmate who was a boyfriend, and there were allegations of involvement in drugs, Your Honor.
All right, my last question is, what is your spirit animal?
I don't know, Your Honor. How do you determine that? I love
You
dogs.
can have a gorilla, baby gorilla.
No, we love dogs, Your Honor. We had a Labrador and a Golden Retriever, but both have left us already. But right now we have a Beagle also, and a Poodle. So So I guess a dog, Your Honor.
All right, thank you. Yes,
Thank you, Your
it's the
Honor.
turn of Deputy Commissioner. Last time I asked you about one coming from the outside of the fence, respect to shortlisting you over other applicants, while Court of Appeals justices who've been with the judiciary for so many years now, who even began as first-level courts. Could that be taken to mean as this regarding careerism in the judiciary? What is your, again, but what are your thoughts on this?
Your Honor, again, no, under the Constitution, with respect to applicants to the Supreme Court, experience, you're only required to have at least 15 years experience in the practice of law, or at least judge for the same period, 15 years. Now, in my case, Your Honor, as I said last time, prior to joining the Bureau of Internal Revenue, I was in litigation practice for more than 20 years. And during my last 5 years as a litigation lawyer, I had a very active courtroom practice that almost every day I was attending court trials. And that gave me the experience, Your Honor, to argue, present and cross-examine witnesses during the trial. Now, after hearings, Your Honor, I spent my time, of course, reading the transcripts in preparation for the for the next day's hearing, review and preparation and review of pleadings. Now, this gave me the doing the pleadings, writing the pleadings, Your Honor, taught me, that you can equate that to writing of decisions, Your Honors. Now, when I joined the Bureau of Internal Revenue, Your Honors, I was into a new environment, technology. I think, Your Honor, in fact, Your Honor, right now we are doing this digital transformation, and we initiated that, Your Honor. And as I said earlier, digital transformation is not only in the executive, it should also be in the judiciary. We should have an e-court, just like what other countries are doing right now. They have the e-justice system. I believe, Your Honor, that this experience, Your Honor, fully equipped me to the position, Your Honor. I may not have the required experience, but this extensive litigation practice can be equated to that of judicial experience, Your Honor.
What other outstanding or compensating credentials you have, while others do not have?
Credentials. Aside from a lawyer, Your Honor, I'm also a certified public accountant, Your Honor. Now, when I joined the Bureau of Internal Revenue, of course, I also have to understand the language of the technology. So I had to do further studies on technology. I took these certification programs on certified information systems, audit and security, and I passed the same. Your Honors, the reason why I'm saying this, Your Honor, is that though I have, yes, handicap in the judiciary because I don't have experience in the judiciary, but again, as I said earlier, no, my cravings for knowledge do not stop, Your Honor. So I can learn the craft also, Your Honor.
So, what is the greatest obstacle you are facing right now?
Challenge, Your Honor. Obstacle on... Your Honor, in what sense, Your Honor?
Nomination?
Obstacle.
By this
I don't find any obstacle, Your Honor, because the requirements of the requirements as provided in our Constitution, Your Honor, I believe that I have fully met all these requirements, Your Honors.
If you could be doing anything, anywhere right now, what and where would it be?
May I request for the repetition of the question, Your Honor? The question is,
If you could be doing anything, anywhere right now, what and where would it be?
I should be
Still here?
still in Singapore right now, Your Honor. Because we are supposed to leave I am supposed to leave Singapore today, Your Honor, but then because of this interview, I had to cut short my study tour, Your Honor.
Have you read the case of People versus Amarela and Racho?
Are these cases 2019 cases, Your Honors?
This penned by Justice Martires before he left the judiciary.
Honestly, Your Honor, I was able to read a number of cases, Your Honor, both 2019 and 2018, 2016. But I focus most on the rulings of the court, Your Honor, and I couldn't memorize the case titles, Your Honor, except for a few. If I may be given the facts of the case, Your Honor, perhaps I will be able to answer your question.
With respect to the acquittal of 2 accused for rape who were convicted by the Regional Trial Court and the Court of Appeals because of inconsistencies in the testimony of the victim, the lone witness for the prosecution. Do you think it is the purported abandonment of the Maria Clara Doctrine?
That particular case, I don't think I was able to read that, Your Honor.
That's all. Thank you,
Thank you, Your
Deputy.
Honor.
But yes, already done. Thank you.
Oh, thank
And,
you very
good luck.
much, Judge Ilaw. I will address the first question to former City Fiscal of Manila, Justice Garcia. Recently, the Office of the President dismissed the Deputy Ombudsman. Does the Office of the President have jurisdiction over him?
Overall Deputy Casimiro or Gonzales? Deputy
Dante
Ombudsman Gonzales.
Karandang.
Karandang.
I think Karandang. Recently only. I think it is pending in the Court of Appeals.
While existing jurisprudence, Your Honor, is on the Deputy Ombudsman Gonzales. In the original decision of the Supreme Court, it upheld the constitutionality of the Ombudsman Act provision that the President has the authority to remove from office the deputy ombudsman and the special prosecutor on the grounds on the same grounds as impeachable officers, because the reasoning of the Supreme Court then was that the power to appoint as the corresponding power to removal in office. However, nevertheless, the complaint against Gonzales was dismissed on the ground that the prosecution failed to prove the allegations of misconduct and betrayal of public trust, Your Honor. On MR, the Supreme Court made a turnaround with respect to the constitutionality of the Ombudsman Act provision and the power of the President to remove the deputy and special prosecutor. Now it ruled that the President has no authority because of the constitutional provision creating the Ombudsman, the purpose of which was to preserve the independence of that office, and since deputies are under the same category as the Ombudsman, who is tasked to investigate graft and corruption cases and the rest, they should be given the independence envisioned in the Constitution. In the case of Carandang, there is the case there is divided rule or points of view. If we go to the original ruling in the Gonzales case, then the office of the President will now we will now recognize the power of the office of the President, President's jurisdiction over the deputies of the Ombudsman. So if it's now pending with the Supreme Court, there will be a revisit by the members of the Supreme Court, Your Honor.
It is pending in the Court of Appeals. Justice Cruz, are you aware of the Gonzales case?
In gist that the authority to dismiss it lies with the office of the President.
Do you know of a subsequent case regarding jurisdiction of the office of the President over a deputy ombudsman?
Over a deputy ombudsman, Your Honor, none, except that case of Carandang.
How Casimiro? Do you know about the Casimiro case?
Casimiro, Your Honor, is a clash between the authority of the office of the President versus the ombudsman law.
Yes, yes.
Which was sustained by the latter law being sustained by the Supreme Court.
What was the ruling of the Supreme Court?
That the authority over the ombudsman in the disciplinary cases involving the ombudsman and her deputies is lodged with not with the OP, not with the office of the President.
Office of the President.
Not with the office of
Not the office of the President. That is the ruling in Casimiro.
But now, in Carandang, the office of the President asserted authority over a deputy ombudsman. That is why Carandang now is before us questioning that authority.
Justice Singh, what is your view? Does the office of the President have jurisdiction over the deputy ombudsman?
Well, Your Honor, based on the ruling in Gonzales, the Supreme Court declared as unconstitutional that provision of the Ombudsman Act, which allows the President to exercise the power to remove the deputy ombudsman, Your Honor.
The Casimiro case is a later ruling. So, what can you say about it?
Your Honor,
The Supreme Court upheld the ruling of the Court of Appeals there.
Your Honor, I believe the difference is that the office occupied by Casimiro was the office of the special prosecutor and not that of the deputy ombudsman, if I remember correctly, Your Honor. And a distinction was made because in the Constitution, the special prosecutor is not a deputy of the Ombudsman, Your Honor, but it was, I believe, the former Tanod Bayan, which was transformed in the Constitution to become the Office of the Special Prosecutor.
Attorney David, what is your view?
Your Honor, I was able to read the ruling, just ruling, portion of the ruling in the case of Gonzales, Your
There are
Honor.
two cases,
In
Casimiro
Gonzales.
and
Gonzales, Your
Gonzales.
Honor. I was able to read only that the Gonzales case, Your Honor. In that case, if I remember it correctly, the ruling of the Supreme Court is that Gonzales, being a deputy ombudsman, can only be removed as provided under the Constitution in the on grounds in the same manner that an ombudsman can be removed under the Constitution, and that is by impeachment, Your Honor. That is my recollection of that case, Your Honor.
Justice Singh,
Yes, Your Honor.
is plea bargaining a demandable right?
No, Your Honor.
Can you explain?
Well, Your Honor, plea bargaining is a procedural measure that is provided for in our rules as a measure also of declogging the jails and speeding up the disposition of cases. So it is not, and we are instructed that there are no vested right in procedural rules. So being a procedural or a remedial measure, then it is not a demandable right.
Do you agree, Justice Garcia?
Yes, Your Honor. The rules in plea bargaining is always at the discretion of the trial judge, Your Honor. And there are many requirements for you to be able to avail of the plea bargaining as to the quantity and kinds of drugs, Your Honor. And the prosecution's recommendation also plays a factor, Your Honor, as to the number of witnesses, or is it easy to, if there is strong evidence to convict, availability of witnesses, etc. That's why it's always subject to the discretion of the trial judge, Your Honor. It's not only a matter of declogging the dockets of the court, Your Honor.
Justice CRUZ?
Your Honor, if what
No,
I
no,
could-
no, no. Another question. What is the curtain iron rule in succession?
The curtain iron rule is that an illegitimate child could not inherit ab iptistato from his or her legitimate relatives.
Can you repeat it again?
That an illegitimate person, Your
Yes.
Honor, could not inherit ab intestato or intestate from his legitimate relatives.
Any
The
other?
bar, there is a bar.
Any other condition, situation?
The conditions are that there must be an intestate succession, and it is established that the deceased is a legitimate relative of the person getting or entering into that succession. It basically
Suppose
Your Honor,
the
to the bar.
deceased is the father. The deceased is the father.
If
What is the rule?
if the deceased is the father, the son cannot inherit from the illegitimate son could not inherit from the legitimate relatives of his father.
Justice Singh?
Yes, Your Honor.
Do you believe the proposition that there are no illegitimate children but illegitimate parents?
Your Honor, there are illegitimate children because our laws provide for it.
If not for that fact, is it not a violation of the Equal Protection Clause in the Constitution?
Well, I think, Your Honor,
Because they are not at fault. Do you agree?
I agree. I agree 100% that they are not at fault. But I would try to say that some provisions of our law regarding the distinctions between legitimate and illegitimate children are justified, Your Honor. But this particular provision, 992, I am in complete agreement that this discriminates against them unfairly. There is no valid purpose for that discrimination, Your Honor, because as explained in that case of Diaz, Your Honor, particularly in the dissenting opinion, it brings about an absurd situation where, as in the Aquino case, the present Aquino case, Your Honor, where the grandchild cannot inherit from the grandparent just because his parents were not married. And so who will inherit from the grandparent is a relative who is farther in terms of relationship than the grandchild who is in the descending line. So I believe that the one who stands to inherit is a niece. So there is that absurdity, Your Honor. So for me, there is no justification that remains to maintain 992, and also because the other provision, 902, in regard to the difference between illegitimate children and legitimate children has already been amended, Your Honor. It was only 992 which was not revised.
Attorney David, you wrote something about Aquino. You heard Justice Singh. Do you agree?
Yes, sir. Your Honor,
You're not going to change, or are you going to maintain what you wrote?
actually, what I wrote in my draft decision, Your Honor, is denying the petition because we have the law. That's 992, and we have this dura lex sed lex. But then, personally, I was thinking about that case, Your Honor. We have this right of representation, Your Honor. In that case, the child merely represented the father.
Yes.
And right of representation, the representative is merely raised to that position of the person represented. And the person represented in this case is a legitimate child.
Do you still make that distinction?
I think we need to revisit that. I think there is a need to revisit that law, Your Honor.
And also
because that is,
you're going to review your answer also.
but I will stick to my answer because we have
Because
we
you
have
stick to
existing valid law, Your Honor.
Because there is a law.
Yes, we have this law.
If there is a law and which is
We have to set-
contrary to the constitutional provisions, what will be your ruling?
Someone should challenge that law, Your Honor. And if I may add, Your Honor, if an illegitimate child can inherit from an illegitimate, in that case, if the father is illegitimate, that prohibition will not apply. So, in my opinion, an illegitimate father is placed in a better situation than the legitimate father, insofar as the child is concerned, Your Honor. Because if his father was illegitimate, he could inherit.
Justice Garcia, with whom would you agree?
I'll stick by the law, Your Honor. It's not for the judiciary to substitute for the wisdom or authority of Congress to enact laws. Let's leave it to them, Your Honor. In the meantime, let's honor the civil code provision. Anyway, there's no legal impediment for that. It's a distinct class for illegitimate children. And the purpose of the authors then was to discourage illegitimate relationship, Your Honor, because it was embarrassing for the family to have to know their parents have other paramours or whatever, and it's a product of sin, sinful relationship, etc.
Can you blame the child for it?
Sorry, Your Honor.
Can you blame the child for it?
No, Your Honor, it's not a matter of whose fault it was, but it's the Congress had the purpose for enacting that provision in law, Your Honor, to protect the basic social institution, which is the family enshrined in the Constitution, Your Honor. Without that, you'll be encouraging other people to enter into a relationship. In fact, the present law, which almost gives almost equal benefits to illegitimate and legitimate children, I do not agree with that, Your Honor.
You're against that? Equal benefits? Are you against
No,
that?
but that's the law, Your Honor. Whether or not, we have to abide by it, Your Honor.
Well, you will be joining the Supreme Court. You will be reviewing the laws.
We have to apply the law, Your
promulgated by
Honor.
Congress.
Your
Suppose
Honor.
it is assailed, as in this Aquino case, that it is violative of the Equal Protection Clause. What will be your view?
There is no violation of the Equal Protection Clause, Your Honor.
No violation, because there is a
No,
distinction.
the requirements for the distinction in the classification are all met, Your Honor, namely germane to the purpose of the law, applicable to all members of the same class, equally. There's a substantial distinction, very manifest, from legitimate to illegitimate children. How can you argue against it? It applies to existing condition as well as to future generation, Your Honor. And even if you apply the test on the for the constitutionality of a provision on equality clause, there's a compelling state interest, Your Honor. Repeat again, the constitutional provision on the family as the basic social inviolable institution, which is a very fundamental, Your Honor, for every family.
Attorney David, Director David. You were asked earlier about reflections, and you answered images.
Mirror. Yes, Your
Do you
Honor.
still maintain that answer? Listening to Justice Tiham.
Honestly, Your Honor, right now I feel like I'm floating because I arrived very late last night from a trip, so I feel dizzy. And though I was asked that question earlier, I actually cannot remember anymore. I don't know what is happening to me. Maybe because I was so tired. So my apology, Your Honor.
Maybe I will ask you questions
If you
on
can
taxation. Does the CTA have jurisdiction to annul, CTA ba, to annul a judgment of the CTA in division?
To reverse the decision of the CTA. in
To
division.
annul, to entertain a petition for annulment, which means the decision of the CTA division has been rendered final and executory. And then, a party claiming extrinsic fraud filed the petition for annulment of judgment. does the city and bank have jurisdiction over the petition for annulment? For annulment of judgment, I'm sorry.
I believe, Your Honor, it's the Court of Appeal. No, it's the
No, are the decisions of the CTA division reviewable by the Court of Appeals?
No, Your Honor. It's going to be to the
You
Supreme Court.
change
I'm
your
sorry.
answer?
Yes, Your Honor.
This CRUZ, what is Rule 47?
47 deals with annulment of judgment of the RTC filed with the CA.
Same question. Can the CTA entertain a petition for annulment of judgment? The CTA for extrinsic fraud
No, Your Honor.
or judgment? Or,
Because-
I mean to say, lack of jurisdiction.
No, Your Honor, because CTA acts, the decision of, to my knowledge, Your Honor, the CTA, the decision of the CTA division is appealable to the CTA in bank. If the CTA decision becomes final and executory, then that's it. There is no provision, I
Suppose
think.
there is extrinsic fraud. What is the remedy of the disgranted litigant?
I think there is no provision in the law creating the Court of Tax Appeals with respect to annulment of judgment. That is precisely, Your Honor, the reason why 47 is not applicable in criminal cases, because there is no applicable provision in the revised in the rule on criminal procedure dealing with that.
Justice Singh,
Yes, yes, Your Honor. Same.
same question.
Your Honor, as stated, the decisions of the CTA in division are appealable to the CTA and bank. However, if the decision of the CTA in division has already become final and executory, there is no, the Rule 47 does not cover the filing of a petition for annulment of judgment of the CTA in division, Your Honor. So what remains would be recourse to the Supreme Court, but then, Your Honor, recourse to the Supreme Court would only either be Rule 65 and Rule 45. So if it's a question of law, it's a Rule 45. And then if there's grave abuse of discretion or lack of jurisdiction, Your Honor, then it's Rule 65. Lack of jurisdiction is one of the two grounds for annulment of judgment. Then that essentially they would be asking for annulment of the judgment on the basis of lack of jurisdiction under Rule 65.
How about extrinsic fraud?
Extrinsic fraud, that's the problem, Your Honor. Only Rule 45, but if it amounts to a question of law, but extrinsic fraud is a factual question, Your Honor. So I don't think...
Justice Garcia, with whom do you agree?
Your Honor, 47 under the rules of court only applies to the Court of Appeals, Your Honor. The CA has its own law on its jurisdiction, which is enumerated in the law, BP 129. The CTA, elevating it to an appellate court, has also its own jurisdiction enumerated in the law. There's no specific rule on the petition for annulment of judgment. In that particular case that has been cited, the remedy is petition for review on certiorari, questions of law, petition for certiorari. It involves lack of jurisdiction without authority or with grave abuse of discretion amounting to lack of jurisdiction. So it can cover the absence of an indispensable party or wrong address, fraud, etc., because the presence of those two renders the jurisdiction of the court null and void. In other words, the CTA then has no jurisdiction insofar as those parties are involved, Your Honor.
What was the reason given by the Supreme Court? Justice Singh? has no jurisdiction to entertain petitions for annulment of judgment of a final decision or judgment which is of the CTA in division.
Well, Your Honor, that Rule 47 is just is limited to judgments of the RTC and elevated only with the CA. So we cannot add to the jurisdiction of the Supreme Court, Your Honor. So petitions for annulment of judgment are limited to the Court of Appeals, Your Honor.
In case of jurisdiction,
In case
lack of jurisdiction
in case
of
of
the CTA in division. Suppose that was the reason.
I thought, Your Honor, you were asking why the CTA and bank cannot entertain it. Okay. All right.
I'm sorry.
So now, Your Honor, why the Supreme Court can entertain?
What was the reason given by the Supreme Court?
Why
In
the
that- in that case,
CTA
yes.
and bank cannot entertain? Yes, Your Honor. Well, precisely. Well, as I mentioned, Your Honor, because Rule 47 speaks of annulment of judgment only in reference to RTC decisions. And it is only with the CA, Your Honor. And also because the power given to the CTA is a power to review decisions which have not yet attained finality, Your Honor. I guess I did not read that particular decision you're referring to.
Is CIR versus KEPCO Ilihan. Are you familiar with that, Attorney David? You are from the BIR.
I was able to read that case, Your Honor, but
What was the reason given?
cases going to the Court of Tax Appeals are cases that coming from the Bureau of Internal Revenue, and there is no
It-
way that a case can
In
be...
ruling that on the issue of jurisdiction of the CTA over CTA and bank over petition for annulment of judgment. So you have not come across it. You have.
I
CIR versus
cannot
Ilihan.
remember that case, Your Honor, but in passing I was able to read, but
What did you read in passing?
I read a lot of cases, but not in this particular issue, Your Honor. But if I remember it correctly, Your Honor, because the jurisdiction of CTA only on cases coming from the Bureau of Internal Revenue, Bureau of Customs, Your Honor, and
That's the general jurisdiction.
Yes, Your Honor.
Anyway, Justice Cruz, do you know the reason given by the Supreme Court in CIR versus Ilihan?
I guess, Your
Kepco
Honor,
Ilihan?
because it is a matter of jurisdiction, and jurisdiction is the authority to hear and determine a case. It is a matter of law. If it is not vested with the CTA in bank, then it has no business tackling that case.
Annulment, the reason given was that annulment of judgment involves the exercise of original jurisdiction. Under Rule 47, the Court of Appeals has original jurisdiction. The CTA has no such jurisdiction. You want another tax case?
Dana's case.
Okay. An action to demand reconveyance of property sold upon forfeiture for non-payment of a tax assessment was brought directly to the regional trial court. The Commission of Internal Revenue was made the respondent. The CIR filed a motion to dismiss. The RTC denied. You are applying the Supreme Court. Suppose the issue reaches the Supreme Court. Will you sustain the denial?
And the reason for the denial, Your Honor, was by the RTC.
Jurisdiction. Are you going to sustain that?
Well, it's only the Court of Tax Appeals that has jurisdiction, Your Honor, other than the Supreme Court.
What is your reason?
On tax cases, Your Honor.
This is a reconveyance of property.
Well, in that case, Your Honor, that is not a tax case,
Not a tax case.
Your Honor.
Justice Singh?
Your Honor, the action is for annulment of the reconveyance. Then it's not a tax case, Your Honor, it's a civil case.
Justice Garcia?
Your Honor, we go to the jurisdiction of the CTA, among which, if it's an internal revenue tax case, review of actions by the Commissioner of Internal Revenue.
Yes.
If it's a local tax, the remedy is to go to the RTC, after which the power to review goes to the CTA per jurisdiction of the Court of Tax Appeals.
So you are going to reverse the denial by the RTC.
If it's involves an internal revenue tax, Your Honor, go first to the regional director, commissioner of internal revenue, exhaustion of administrative remedies, then to the Court of Tax Appeals.
So
Your
you
Honor.
will reverse the regional trial court.
Yes, Your
The
Honor.
action was filed, prayed for the reconveyance of property. Justice CRUZ, with whom will you agree?
This is assuming there was a foreclosure of mortgage for non-payment of real estate taxes.
Yes.
Normal
So
cases
it was
must be-
sold upon forfeiture for non-payment of tax assessment. Oh, Justice CRUZ.
Your Honor,
would you
if the
agree?
object on the part of the plaintiff is for the recovery of the property, then the action should be lodged with the RTC.
RTC.
Yes, Your Honor.
Okay, 3-1. The ponente is the Chief Justice. He will be voting. He did not sustain the RTC. He reversed the RTC. I don't think he's watching. I will direct this to a former city prosecutor, Justice Garcia. Are you familiar with the good conduct time allowance?
Yes, Your Honor.
Yes.
Considering that
You are aware of Article 99?
on the
Yes, Article 99. Are you aware of that provision? Sige, I will read. It says that once granted, the allowance for
cannot be
good
revoked.
conduct cannot be revoked. What is your take on that?
It should not be taken literally, Your Honor. Once granted should mean that all the requisites have already been complied with. Otherwise, it is void. So there's nothing to revoke, Your Honor. There are so many lapses in the grant of good conduct in the Bureau of Corrections, Your Honor. First, it was not signed by the authorized persons in the person of the director of the Bureau of Prisons. In the news, it says that many were just signed by the deputies. Secondly,
Going to that, I'm just asking about
Sorry.
that sentence. What is the remedy then? Legislation or judicial interpretation?
in the meantime, Your Honor, judicial interpretation, Your Honor.
It should be brought before the court.
Either way, Your Honor, since the President has ordered the rearrest of those who had been granted and released, once arrested, the convicted prisoner himself can go to court on certiorari. Those who have not been, those who have not surrendered, but a manhunt is in order, they have to secure the warrant of arrest from the court. In both cases, the court can rule on the validity or invalidity of the grant of good conduct to the released prisoners, Your Honor.
Justice Cruz, under those circumstances, can the President order the rearrest of the released prisoners?
I think, Your Honor, I will have to qualify. There were prisoners released where the release orders were void. Void because the computations were purposely done wrong or it was tainted by corruption. In that event, I guess the President could order their rearrest because
Should there not be a hearing first?
I guess there would no need for a hearing because that situation, Your Honor, I guess would be akin to a situation where the prisoner has evaded his sentence. You do not need an arrest order for that because under the rules, a person who evades his,
Evaded the sentence.
yes, Your
The
Honor.
prisoner evaded the sentence. Who committed the miscalculation or the computation? Will you not accord a presumption of legality or
No, Your Honor, because
regularity?
precisely, the release order is void. It was done with in conspiracy with some Bucor official. If it is void, then
There is no hearing yet. Is there any hearing? Have they been heard?
because it precedes, Your Honor, that the recomputation was wrong.
Is there no violation of the due process clause? Should they not be heard first?
Because on its face, Your Honor, if the recomputation is void, you do not have to accord them due process because precisely they have escaped their sentence.
Because under the law, their sentence was reduced. They were given time allowances.
Correct, Your Honor.
So there is no sentence to evade.
Correct. If the computation is correct. But if the computation was done purposely for the prisoner to escape or to get a release order, then the release order is void.
Has there been a recomputation?
There, I understand, Your Honor, that
So
the computation were purposely
does the
done.
President have basis?
I guess, Your Honor, yes. But if the computation was correct, then the inmate, the prisoner, in that situation would be entitled to due process. You will have to go to court and get to the court which convicted the prisoner and the prisoner now explaining why the release was valid.
Attorney Singh, what is your take on that? I believe the release, the order of the President was not conditioned on anything. What is your take on that?
Your Honor, first, as far as the statement of the President, I believe that it was an administrative directive to those in the executive branch that this is what needs to be done. You have to get these people back inside, let's recompute, and if we find out that, that they are not entitled to be released yet, then we do the necessary. And what is the necessary? Your Honor, I believe the case of Fidel Tan and the case of City Jail of Manila versus Estrella are much in point. No?
There was a basis for that in the Tan case because there was a wrong recomputation.
Yes, Your Honor.
Wrong computation, I mean.
Correct. But
here, there is no recomputation.
yes, Your Honor, but my point is, that's why, Your Honor, so the President said, let's get them back in, that's the administrative side, for the executive branch of government to do, for the DOJ and the Bureau of Corrections. If we find out that these people are not yet entitled to be released, then these people should go back inside the jail. They can go back voluntarily or they can refuse to, and that's when we will have to go back to the court, which is what we learned from TAN and from City Jail versus Estrella, that is the proper procedure, because this still involves implementation of your judgment of conviction, the service of sentence. And so the release of a convict serving sentence for GCTA, Your Honor, is part of that process. The court retains its jurisdiction. So we have to go back to court if we want to have those persons rearrested, Your Honor.
We want those persons to be arrested.
Rearrested, Your Honor,
But
because
they were already ordered to be rearrested.
Your Honor, my view, as I stated at the outset, is that when the President said that, it was an administrative directive to
his subordinates,
to the members of the executive branch, Your Honor.
How
Yes.
about the rights of those who were released?
That is why, Your Honor, they are being asked to submit to the process. If they refuse to submit to the process, Your Honor, then that is when the jurisdiction of the courts can be invoked, so that they can be brought back to the penitentiary, Your Honor, to finish the service of their sentence.
Attorney David, what is the rule of law?
The rule, Your Honor, everyone is bound to obey the law, Your Honor. No one is above the law. That was also asked last time. Everyone, person, entity, organization, no one is above the law. So we are all accountable. We are all supposed to apply and follow the law, Your Honor. That's the essence of rule of law, Your Honor.
What is what are the 4 universally accepted principles regarding the rule of law?
Based on what I read, Your Honor, it's supremacy of the law, accountability to the law, equality before the law.
Sleepy.
These are the principles, Your Honor, that mentioned in the DOJ, Your Honor, DOJ website. Principles of rule of law, Your Honor.
Justice Garcia, what is the blameless ignorance doctrine?
Your Honor, it's an act of omission or mere silence. Making one believe that you agree to a thing, but actually, or intentionally or negligently avoiding to inquire about an incident where definitely suspicions arise that something wrong happened. Thinking, yung mga walang pakialam, Your Honor, thinking that you don't get the blame if a crime has been committed or whatever, Your Honor.
Justice Cruz, what is blameless ignorance doctrine?
Blameless ignorance doctrine,
Yes.
Your Honor, is one where you could not blame the prosecution or the private complainant of something which they did not know in the first place, which in turn resulted into the crime having been prescribed, or which allows prescription to set in.
Justice Singh?
Your Honor, in relation to the prescription of action, the blameless ignorance doctrine provides that you cannot start the running of the prescriptive period from the date of the issuance, because if the person against whom prescription will run has absolutely no knowledge of the issuance of that certification or registration. And so, because of their blameless ignorance, meaning they were in good faith all along, Your Honor, they had no means, no clue that that act already happened. So, it should be from knowledge that the period of prescription should start running.
Attorney David, where is this doctrine usually used or applied?
If I remember it correctly, Your Honor, I think it was applied in the case of RCBC. Wherein the
Compares
officials-
to this applied in cases of inordinate delay. It was first mentioned in the case of Desierto, and then last year in the case of Rosario versus People. Anyway, Attorney David, what is the overbreadth doctrine?
Overbreadth doctrine, Your Honor, that is applied in areas involving freedom of expression, Your Honor. Under that doctrine, Your Honor, even if as applied to you, as applied to a person, the statute is even if as applied to you, the statute is Your Honor, even if as applied to you, if the statute on its face appears to be void because it is vague and overbroad, you can question the constitutionality of the law, Your Honor, even if, again, as applied to it appears to be valid because you're not affected. And the reason for that, Your Honor, is because of the chilling effect. So, chilling effect of the law being invalid or void, Your Honor. So, again, as a rule, you can only question the constitutionality of a law if, as applied to you, it is invalid. But in the case, Your Honor, in case the statute is vague and overbroad, Your Honor, even
That's
if
void
you are
for
not void
vagueness.
for vague, Your Honor.
That
You
what is
can-
the difference between the two?
Yes,
Overbreadth
it is overbread, Your Honor. You
void
can, that's
for
a
vagueness.
facial challenge, Your Honor. So you can challenge that on its face, Your Honor.
Where is this usually applied? Void for vagueness.
In cases involving freedom of expression, Your Honor.
In criminal
Cases, Your Honor.
Overbreadth on
Violation of freedom of
overbreadth is usually used in libel cases,
Yes, sir,
defamation.
Your Honor.
Like that. Now, going back to that, you answered reflections are images. What is the mirror doctrine?
If may I be guided again by the court about
It's under land registration cases.
okay, Your Honor. Now I remember. In land registration cases, Your Honor, you are supposed to, you're not bound to check outside the four corners of the title, Your Honor. You only have to check the title on its face. But then, if you find something irregular, Your Honors, like, for example, if the seller of the property is not the owner and you find irregularity in the transaction, then you are supposed to inquire even outside the title. So you have to be, vigilant, Your Honor, in finding the legality of the title, Your Honor. So you are not supposed to limit yourself on the four corners of the title, Your Honor. That's mirror doctrine.
Justice Cruz, what is the rule on deficiency after the judicial foreclosure of mortgage? Yes, what is the rule on deficiency? Can you please use the mic?
The rule, Your Honor, is that the mortgagee is entitled to a deficiency judgment if the result of the foreclosure was not sufficient to cover the total indebtedness. That would be the deficiency, and he has to file it separately from the foreclosure.
Can he file it in the foreclosure case, judicial foreclosure?
No, Your Honor. It must be a separate action.
Justice Garcia.
Deficiency judgment in real
Yes.
foreclosure, Your Honor, the creditor, unlike the foreclosure of personal objects, in real estate, the creditor is still entitled to the deficiency,
Yes. What
meaning
is the
over and
remedy?
above the price in the public auction. It has to be filed in a separate civil action for collection of sum of money, Your Honor.
Can it not run or collect the deficiency in the same judicial foreclosure proceedings?
No, Your Honor, that's the subject of matter of different action because definitely the previous action must have been terminated or commenced, and this one arises only subsequent to the fact of public auction or foreclosure sale, Your Honor. And to separate the issues and cause of action, Your Honor, as required in the rules, Your Honor.
Okay, Justice Singh.
Yes, Your Honor.
Same question.
I believe, Your Honor, that you can recover the deficiency in the same action. Otherwise, that will just result in multiplicity of suits when the issue is already foursquare before the court.
Under what conditions?
You have to first exhaust. So foreclose, and if there is a return already, that there is that the amount is insufficient to satisfy the obligation, Your Honor, then you have to move for the court to issue a deficiency judgment.
Are there conditions imposed by the rules or jurisprudence?
I guess, Your Honor, there has to be observance of due process. You have to hear the debtor again.
Tony David.
I think you have to file a separate action,
Separate?
Your Honor, to recover the deficiency.
Well, in the case of Backrack Motors, you can collect in the same judicial foreclosure proceedings as long as it is included in the pre-trial brief. That's the ruling in Backrack. And also Central Visayas Finance Corporation versus Adlawan, GR 212674, March 25, 2019. Okay. Oh. Sige. I will, Justice Singh, you teach or you are a lecturer on legal ethics?
Yes, Your Honor.
Okay,
I
I will ask
Yes.
this question. Siguro last ka na lang.
Last na po ako. Okay, thank you.
Justice Cruz, what is a child purchase contract?
Child purchase contract, Your Honor,
Yes.
is a contract which is onerous on the part of the lawyer charging it against a client.
Justice Garcia?
It's more of an action of the lawyer telling the client or paying for the expenses and cost of litigation, which is not allowed because it will this will result in the possibility of the lawyer looking after his interests rather than the interest of the client, Your Honor.
Attorney David, with whom do you agree?
Your Honor, I think the Champertus contract is one wherein the lawyer agreed to advance the expenses of the litigation, Your Honor.
We will ask the lecturer, Justice Singh.
Your Honor, a Champertus contract is prohibited under our Code of Professional Responsibility. It is a situation where the lawyer invests in a case because he advances the expenses, and the agreement, he enters into an agreement with the client that whatever we recover, we will share it in a proportion that they will agree upon.
That was my last question. Thank you very much. Your excuse.
That concludes the fourth or the last of the series of public interviews of aspirants for a seat in the Supreme Court. We would like to thank the candidates for your participation. We wish you all the best. We would like to thank also Honorable Justice Marvic Leonen and Honorable Justice Andres Reyes for acting as presiding officer last Monday. And kudos to the honorable members of the Judicial and Bar Council for your remarkable stamina, your keen mind, your witty and wise questions, which at times are injected with humor to lighten the mood. To the staff of the Maintenance Division and the PIO, thank you very much. Have a great day, Your Honors and everyone.